I'd like to recognize the ranking member on the Committee of Ethics for an opening statement.
Thank you, Mr. Chairman. As the chairman noted, we are here to consider allegations concerning Representative Cherfilus-McCormick. The Ethics Committee has a solemn duty under our constitutional authority to enforce standards of conduct in the House of Representatives, to investigate claims of member misconduct, and deliver accountability where appropriate. It is a responsibility we all take extremely seriously, without regard to partisanship or bias of any sort, and without the presumption of guilt before innocence. As we begin today, I want to reiterate that the process is not adversarial in the traditional sense. It is not a criminal trial. It is an inquiry to determine whether Representative Cherfilus-McCormick conduct violated House rules and ethical standards. Let me underscore that the subcommittee's role is to ensure that the factual record is carefully examined, the process remains fair, and the conclusions reached are grounded in evidence and consistent with the House rules and committee precedents. We, as judges during this phase of the proceedings, must determine whether committee counsel has proven the allegations by clear and convincing evidence. The Ethics Committee operates within a framework of precedent, rules, and long-standing institutional norms. These guideposts exist to ensure consistency and fairness across investigative matters, regardless of the individuals involved or the surrounding circumstances. We will adhere to those same principles today as the committee does in all of its investigations, and just as the committee has done since it began reviewing these allegations in 2023. Today's hearing follows a 24-month-long bipartisan investigation by an investigative subcommittee, or ISC, comprised of an equal number of members from the majority and minority parties. The ISC received testimony from 28 witnesses and reviewed hundreds of thousands of pages of materials. Based on that record, the ISC produced a 27-count statement of alleged violations and unanimously found substantial reason to believe that each of those counts were supported by the available evidence. All along the way, Representative Cherfilus-McCormick has been afforded the opportunity to share evidence with the ISC and directly address the allegations against her. Hearings like today's are very rare, as the committee often loses jurisdiction over respondents before this phase of the committee process. And the allegations before us are extremely serious. They not only concern an individual member's conduct, they also implicate the public's confidence in the House's integrity as an institution, and if proven, they would demonstrate that the representative violated, if proven, multiple House rules and federal statutes. The adjudicatory subcommittee is, of course, aware that the Representative Cherfilus-McCormick has been indicted on federal charges and a criminal trial is pending. We carefully considered her request to stay these proceedings pending the outcome of that criminal case. Yet we unanimously declined to do so, given our committee's independent mandate to self-regulate member conduct and the constitutional limitations the executive branch faces in investigating members of Congress. The opportunities provided, Representative McCormick declined to engage with the committee's process over the last several years, and the need for public transparency around these allegations. Public office, by its definition, derives from the will of the people, and transparency is essential, obviously, to maintaining the public's trust. The American people deserve for their institutions to uphold ethical standards, and the American people are entitled to demand accountability of all of us if their elected representatives are without integrity, if they prefer personal gain over public service, and if they act in a manner that reflects discredit on the House. It is in this service of these foundational principles that we convene today. At a time when public confidence in our institution is so low, this committee's role in enforcing congressional ethics process, and defending the integrity of the House could not be more important. As Supreme Court Justice Louis Brandeis famously said, "Sunlight is the best disinfectant." With today's public hearing, we have the opportunity to shine that light and that spirit on this committee, this matter, and in the House, and to bring about the transparency that I believe the public expects and demands from this institution. Thank you, Mr. Chairman. I yield back.
Thank you, Mark. The first order of business is for the adjudicatory subcommittee to consider a motion to reconsider. That motion to reconsider involves previous rulings that the adjudicatory subcommittee made last week. The first was a motion to stay this proceeding past the criminal proceedings, and the second was a motion to hold any adjudicatory subcommittee hearing in executive session. After rulings by this body, there has been a motion to reconsider that has been filed by the respondent. That was filed by the respondent by her counsel, Mr. William Barzee. Ms. Barzee, this is your motion, and so at this time, we will turn it over to you to make argument on your motion to reconsider.
Mr. Chairman, as the ranking member pointed out, Congresswoman Cherfilus-McCormick was charged in federal court and has a pending federal criminal indictment. A very serious affair, which she takes very, very seriously, just as she takes this committee's action in self-regulating the members of the House to be a very serious affair. Inherently, however, there is a conflict between participating in both of those arenas at the same time. And I want to just take a couple of moments to try to explain to this committee why going forward with an adjudicatory hearing when a member has a pending criminal case is a very risky endeavor. And when I say risky, the risk is to a violation of her constitutional rights to a fair trial. And I want to explain how those rights are implicated by this committee moving forward at this time. The first and most serious issue is the fact that, as the ranking member pointed out, this is not a criminal trial. And as such, it's going to have different standards of proof are going to be involved, different rules of evidence are going to be involved, and a different decision-making apparatus is going to be involved. It's not going to be decided by a jury of her peers. It'll be decided by the members of the committee and the full House. That being said, the public down in the Southern District of Florida, the pool of potential jurors who are going to be hearing this criminal case are going to be inundated with information about what takes place in this committee. They will learn about evidence related to the allegations in the criminal case from what takes place in this committee. Now, not all of that evidence may be admissible in a criminal case in federal court. It may be admissible here. You may want to call forth different witnesses to get testimony when those witnesses may not necessarily be on the stand and testifying in front of a jury. So the potential here, the difficulty here is that you are going to have members of the public who are also potential jurors in the criminal matter hearing about facts that they otherwise would never be exposed to. And those potential jurors can end up on her jury and can include those facts in their decision-making in an inappropriate way. That's a major, major risk. The other risk that the committee should consider is the fact that whatever this committee decides, if you decide that there was a violation of one of the rules, for example, no one on this committee has any control over how the press reports that. And the danger here is in today's society, without pointing fingers or blaming one side or the other, everything has become weaponized, including the press. And you are going to see press reports indicating that the Congresswoman has been found guilty of these various allegations that were made against her. Now, how can she possibly go into court and have a fair trial if her jurors have already heard that she was found guilty by the House of Representatives? It's an impossibility. I mean, jurors are human beings. A federal judge can say to a juror, now listen, that was in the House of Representatives and that has nothing to do with this case, and you have to promise me that you'll put that out of your mind. And of course, every juror would immediately say, yes, Your Honor, we promise. We won't consider that. But they're human beings, just like all of us. And if someone covers this, or they read a press report, and they get an impression because of the way the story is told that the Congresswoman has already been convicted by the House, how can she have a fair trial? Any action by the committee is going to violate those rights. And I would suggest to you that those rights are fundamental. They're what makes this country great, the right to a fair trial. And if this committee takes action that violates that rights, then what is the purpose? We don't want to be doing that. We don't want to be doing it to this Congresswoman. We don't want to be doing it to the member next year or 2 years from now or 10 years from now, which is why it makes sense if there is a pending criminal case that this committee should just simply pause. Allow the criminal case to work itself out so that there is no risk of tainting a jury. Now understand, it's not just a situation where potential jurors may read about this in the press. Everything is weaponized today. So they're going to be seeing it on their Facebook reels. They're going to be seeing it on TikTok, on Instagram. It's going to be nonstop. And assuming that it is nonstop, assuming that her political opponents use whatever happens in this committee against her in the campaign, which is fair enough, but imagine the impact it is going to have on potential jurors. You know, trial attorneys have a saying about, and I know that more than one member here has experience in courts, they have a saying about how you can't unring the bell. Once you hit the bell, it's going to reverberate. People are going to continue hearing it. It's going to have an effect. And it doesn't matter that I can ask a federal judge to instruct a jury to disregard everything that they've seen in the past 6 months on Facebook and Instagram and TikTok. It's not going to happen because potential jurors are real humans. And humans really don't have that capacity to simply put something completely out of their mind. It's always going to be there. And if it's always going to be there, then there's always going to be a risk that the Congresswoman is not going to be able to get a fair trial. And that's not a mistake that this committee has to make. This committee can simply allow this to remain in a pending schedule until the criminal case is resolved. The second biggest issue that I see with her rights being violated is her Fifth Amendment right to remain silent and to say to the government, if you're going to accuse me of a crime, come into court and prove it. And by the way, that's exactly what the Congresswoman has done. She is not guilty of these allegations. She's absolutely innocent. She's looking forward to being in criminal court in order to prove her innocence, which I'm confident she's going to be able to do. But she's in between a rock and a hard place right now when the committee says, well, give us all of your files and allow us to cross-examine you about everything that happened. Well, if she complies with that, if she engages in that process of turning everything over and speaking to the committee, everything she turns over, everything she says to the committee could potentially be used against her in a subsequent trial. I'm not saying it absolutely will be, but I'm saying that that potential is there. And if there is a significant potential that the actions of this committee are going to deny a member a right to a fair trial, or deny a member's constitutional right to remain silent, I would suggest that the committee could take a pause. Mr. Chairman, I understand that this committee and staff have been working on this matter for over 2 years, maybe up to 3 years. I understand the impatience to get things resolved and get things accounted for. And those are noble goals. And expediency is a noble goal. But it's not more noble than her right to have a fair trial. And it's not more noble than her Fifth Amendment right against self-incrimination. You know, staff counsel has mentioned a few times that the only time that this committee has stayed cases was at the at the request, maybe I meant direction, but I'm going to say request, at the request of the Department of Justice. Now, why does the Department of Justice come before this committee and ask for matters to be stayed? Well, the Department of Justice does that on a routine basis because they don't want their cases harmed. They don't want to run into problems with their cases, with their witnesses. And so the Department of Justice comes to the committee and says, we're asking you to defer. And this committee regularly defers when asked to by the Department of Justice. Because you want things to be fair for the Department of Justice. Because you don't want to interfere with the important work that the Department of Justice is doing. And those are noble and appropriate reasons to defer. Well, anyone watching this on TV, sitting on their couch, is going to ask the same question that I'm going to ask the committee. And that is, if it's good enough for the Department of Justice to be able to protect their case, why isn't it good enough for the member to be able to protect her constitutional rights before a criminal trial in federal court? If you routinely defer to the Department of Justice, why not defer to one of your own members who has a pending criminal indictment hanging over their head? One of the things that I've seen is the issue of not wanting to interfere with the Department of Justice's strategic approach to their case. Meaning, we don't want to interfere with the Department of Justice's plan on how they're going to present evidence and which witnesses they're going to call and which witnesses they're not going to speak to. And the Department of Justice doesn't want this committee getting things confused. They want to have full and complete control over everything from beginning to end. And I respect that. I mean, all lawyers are in some way control freaks, right? And so I get it. I get why the Department of Justice wants to shut the committee out so that they can do their job. And there's no problem with that. That's probably an appropriate thing for the Department of Justice to do. And it's an appropriate thing for this committee to accept those requests by the Department of Justice and to pen this. The Department of Justice has never come in front of this committee and asked you to throw a case out because it might interfere with their work. What they do is they say to you, please, House, take a pause. Let us finish our investigation. Let us finish our case, and then you can pick up where you left off. That's all we're asking. I'm not asking you to dismiss this because there's a pending criminal case. I'm not coming in here banging on the table and arguing about things like double jeopardy and she should only have to answer to one authority. No, not at all. In fact, the Congresswoman takes the work of this committee very, very seriously, which is why when her former attorneys withdrew from the case, she scrambled to get somebody on board to represent her before this committee as quickly as she possibly could. The staff has been working on this case, as you know, for 2.5, 3 years, I think. I've had the case for, what, 2.5, 3 weeks? And I'm at a position now where I'm supposed to stand up and represent a duly elected member of Congress before this body without really knowing what's in the file. Because 2.5, 3 weeks is simply not enough time in order to review all of the work that's been done on this case. Hundreds of thousands of documents, lots of different witnesses. This committee knows that there was a date a while ago for us to respond to the motion for summary judgment, and we were not able to file a response. That wasn't because the Congresswoman is somehow disrespecting this committee. It's because she didn't have counsel until 2.5, 3 weeks ago. We want to respond. I want to respond more fully than we have in the most recent filing that we sent to the committee this afternoon. We've already submitted one affidavit from a witness. It's clear that there are factual disputes here on both sides. I'm not going to get into an argument on the summary judgment motion. I'll keep it to just the issue of requesting a stay. But all along, the Congresswoman has wanted to show full respect to this committee and has wanted to cooperate fully with this committee. And on the advice of counsel, because of the pending criminal investigation, she has not been as forthcoming with materials and testimony as the committee would appreciate. And we understand that, and I understand that completely. And those concerns will no longer be at risk once the criminal matter is resolved. You know, this idea of postponing a hearing on summary judgment, for example, because of a pending criminal case is not my idea. I didn't think of that argument. That's a long-standing process, even in federal courts, in civil cases. I have a case here from one of the greatest federal judges in the United States, Judge Hale in Kentucky. And the name of the case is Norman Quartermouse versus Bullitt County Fiscal Court. And it was the same sort of situation where there's a pending criminal case. And I know a few of you probably know the judge from Kentucky. There's a pending criminal case and the plaintiff is moving for summary judgment. And I just want to quote what the judge said. Because the criminal case prevented the, I'll say, respondent from having an opportunity to develop and discover the evidence he or she would need to support his claims, common sense dictates that the court should defer consideration of the defendant's motion for summary judgment in light of the criminal action. So this isn't something that, you know, some slick criminal defense attorney is coming in trying to convince you to hold off on going forward. I mean, this is a fundamental idea here that you don't interfere with someone's constitutional rights if you don't have to. And you don't have to. Granting a request to stay these proceedings until the criminal case resolved in no way diminishes the importance of what this committee is doing. In no way does it take away this committee's ability to self-regulate or the House's ability to regulate the members. All of those things are still going to be here as soon as the criminal case is resolved. And if this committee were to defer and were to stay the hearing until after the criminal case was resolved, it would be doing so in support of the United States Constitution. It would not be doing so because it's trying to protect a member or not fulfilling their obligation and their duty of self-patrolling their members. You would be doing it for the right reason. And ultimately, committee, that's why we're asking you to stay this hearing at this time, for those constitutional reasons, as well as for allowing me to have some opportunity to prepare a response for the summary judgment motion, to call witnesses on her behalf, to develop these facts that are absolutely 100% in dispute. Thank you, Mr. Chairman.
Thank you, Mr. Barzee. I would now recognize Committee Counsel Ray Radican to respond to the motion to reconsider.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Ranking Member, and members of the Adjudicatory Subcommittee, committee staff asks that the Adjudicatory Subcommittee stand by its ruling denying respondents' requests for a stay of these proceedings and alternatively to proceed in executive session. The arguments raised in respondents' motion to reconsider are the same points that were already briefed and argued to this subcommittee prior to today's hearing, and the latest motion raises no basis for the subcommittee to reverse its decision. Respondents' request to stay this matter or to proceed in executive session should remain denied. With respect to respondents' request to stay these proceedings, committee staff acknowledge respondents' pending criminal prosecution. However, under Article 1 and House rules, the House and the Committee on Ethics have their own unique authority and obligation with respect to alleged misconduct by members of the House. Respondent has not been and will not be compelled to testify in this matter or to otherwise forfeit her rights under the Constitution. A stay is not required by precedent or policy. Despite being aware of this investigation for years, the Department of Justice did not request a full deferral of these proceedings, and it was not until January that the Department of Justice requested a limited deferral, limited to collecting witness interviews. By that time, the interviews were already completed and the request was already moot.
Excuse me, can you get closer to the mic?
Yeah.
Thank you.
The bipartisan investigative subcommittee conducted a thorough review over 2 years and weeks after respondent was indicted, determined to move forward and to adopt the charges before you. The investigative subcommittee felt that respondent had caused enough delays throughout its reviews. Respondent's criminal trial has already been delayed, and although that trial is currently scheduled for April, respondent's counsel acknowledged to the subcommittee that he anticipates the trial will be further delayed. There is no guarantee respondent's criminal trial will take place this year or soon thereafter. There is a significant institutional interest in proceeding without further delay. Respondent's motion to reconsider her request for a stay should not be granted, and today's hearing should proceed as scheduled. The subcommittee has soundly exercised its discretion in denying respondent's motion, and it should not reverse that decision now. Thank you.
Thank you for that response. The members will now have the opportunity to ask questions of both counsel. We'll begin and we will rotate that. I will begin and then Mark, and so we will rotate that by members of the Adjudicatory Subcommittee. Ms. Brazier, for the record, I think it's been stated that this matter has been under investigation by the committee since 2023. This has been a very slow, a very deliberate process. There has not been a rush to judgment in this matter. And I will say that I'm aware of multiple occasions to where requests were made of the committee, requests for additional time to hire attorneys, and that was done in your case. I think you were at least the third attorney, possibly the fourth attorney who the committee has dealt with during the course of this. We have granted extensions for not only the right to retain counsel, we've granted extensions on timing to respond to motions. We've allowed motions to be responded to after deadlines. And so I think that the committee has made, at least up to this point, a good faith effort to try to make sure that we are protecting the rights of your client. Counsel for the committee did bring up, and I think you stated last week that you intended or expected, let me say that, you expected the criminal matter, which was set next month, to be continued. And there were conversations between you and the U.S. Attorney's Office while nothing had been ruled yet, but you did expect that there would be some continuance. That continuance, I would assume, would probably likely be to summer or fall at the earliest. And then we also made you aware of certain blackout periods that would come into play. And that would then further negate our ability to resolve this matter in a timely fashion. At this point, you've not made a motion for any certain time of continuance. Your motion has been to continue the matter past the criminal action. And so my question to you is, does there exist a circumstance in your mind where the Ethics Committee, not just in this case, but in any case, that we should make a finding if there's a pending criminal case? The Ethics Committee, I think, in the Santos matter, which was the most recent matter in which we had a member that was under federal indictment, in that matter, the committee conducted an investigation. The committee issued a report, and then based on the report, the House then took up a motion to expel, a motion that I sponsored, to expel Mr. Santos based on his conduct that had been found. And so you're right when you argue that we did not go through this. These are additional protections for which your client is receiving that Mr. Santos did not. But my question is, and one for clarity, you're requesting you're not requesting additional time, but you're requesting that this matter be continued past the criminal matter, whenever that may be. And then the second question is, do you believe that there exists a circumstance where a member who was charged with a crime, that this committee should make findings or recommendations until that criminal matter is resolved? So with that, I'll give you the opportunity to answer the question.
Thank you, Mr. Chairman. I recognize the good faith efforts that the committee has made up to this point, without question, and I want to acknowledge that. I do want to correct one thing that staff said about the criminal matter. Staff indicated that the criminal trial has already been delayed once, and that's incorrect. It has not been delayed. It is currently set for trial in April. I agree with the chair. It's most likely late summer, early fall, but I'm not the judge, so I don't get to decide that. As far as the question as to whether or not it would be possible to address this prior to the resolution of the criminal trial, I would like to answer that by explaining that there's really two different major difficulties with going forward at this time. One of them are the constitutional concerns that I raised before about a tainted jury and the Fifth Amendment right. Those concerns would not be addressed with a hearing in this committee prior to a resolution of the criminal case. So if the concern is protecting a member's constitutional right to a fair trial, if the concern is protecting a member's constitutional right to, for example, exercise their Fifth Amendment to remain silent, and of course, she's not being compelled here to testify by staff, but her lawyers are telling her you can't get up and start talking about it until we have the criminal case, just to clarify. So for those concerns, the only way to address those concerns would be to pending the criminal case, staying this until the criminal case is resolved. The other difficulty is the fact of the matter that I've been on the case for about 2.5, 3 weeks. And to expect an attorney to go through hundreds of thousands of documents and multiple witness statements and interviews, and then prepare their own witness interviews and affidavits and respond to evidence that's been accumulated for 2.5, 3 years in a period of 2.5, 3 weeks is impossible. Absolutely impossible. So if one of the concerns is that she is or that the member is represented by a competent counsel that's prepared in these hearings, then that concern could be addressed with a delay shorter than staying the matter until the resolution of the criminal case. The chair pointed out the timeframes before the elections that you're running up into, and I understand those concerns and I appreciate them and I share those. I still think it would be possible for us to, if the concern was making sure she had competent counsel to represent her, then a shorter continuance would be possible to maybe sometime in the beginning or middle of June in order to sort of develop these arguments, to respond to the motion for summary judgment in a thorough way. We did our best in the last few hours putting something together, but to really give it the amount of attention that it deserves, it's going to take work. It's going to take time. And so something more than 2.5, 3 weeks would give me enough time in order to come before the committee prepared and offer competent counsel to the Congresswoman. And I've no doubt that every member of this committee wants the Congresswoman to be represented by a competent attorney who's going to do a good job. Because the only way you're going to get to the truth, the only way you're going to discover what really happened is if you hear from both sides and you have competent attorneys on both sides presenting the facts to the committee and cross-examining witnesses. And that simply cannot happen in the time frame that we have in front of us right now. Clearly, the committee has a desire to get this resolved in a timely fashion. And I completely understand that, Mr. Chairman, and I appreciate that. Understand, from my point of view, from my perspective, rushing into this, from my perspective, I'm not saying that the committee's rushing, but for me to rush into it, having only had the case for 2.5, 3 weeks, that's dangerous territory. I mean, lawyers really shouldn't be practicing law like that. You don't want a doctor running into a surgery unprepared, not sure exactly where in the brain she's going to operate on. I mean, things take time. And what I'm asking the committee is, putting aside the constitutional risks involved, which is why we're arguing to the committee that in order to protect those rights, a stay would be appropriate, but also for reasons of her having a competent counsel, I would suggest to the committee that a continuance to allow me time to prepare a thorough response to the summary judgment motion and to raise for you in a coherent way all of the facts which we disagree with that the committee has compiled and presented before you. The committee staff has compiled, rather.
Barty, my time's expired, and I will recognize the ranking member, but just for the record, there has been no request made for additional time. The only request that you have made, or your client has made to this committee, is to continue the matter past the criminal action.
Yes, sir.
And so I want the record to reflect that we have ruled on that motion and we are here to reconsider that, but there has not been a request made to continue today's hearing. So with that, I recognize the ranking member for his 5 minutes of questioning.
Thank you, Mr. Chairman, and I appreciate your comments and as well as counsel. So my question is sort of, if not now, when, following up on the chairman's, how long do you expect the criminal trial to take? And I say this in the context as a non-lawyer, having read everything I could about this case in the public and what we have, a lot of it is already public, particularly in Florida. So while we want to be respectful of due process, when is this going to play out in your estimation, given your experience as a trial attorney? And then in the context of what I struggle with, the reason this is separate institutionally, constitutionally, is we have while we want to respect the constitutional rights, we have an obligation as given to us. And having watched the previous time we had a case like this in the Rangel case, was not dissimilar in some ways from the argument that he provided in this room in 2010. So the questions are, if not now, when, in the context of much of what we are going to hear today has already been very public, particularly in Florida and the Florida media.
So,
Actually, there's three questions. There are those two, and put yourself in our position as we are required to do to protect the integrity
right.
of this institution, including if we hear the evidence as quickly. I'm reminded of the expression justice denied is justice delayed. We're doing a disservice to our responsibilities in this committee if we don't act with a level of concern about how quickly we adjust or we address the issues of justice, irrespective of what the conclusion is.
Sure. Well, I mean, I think the answer to that question is the committee should do everything in its power to get this issue resolved as soon as it possibly can be resolved, while protecting the members' constitutional rights. Right? I mean, that's it. The fact that there have been lots of stories in the press, and I agree with you, there have been lots of stories in the press. There is a tremendous amount that is not in the press. And really, that's what my concern is. For example, there's at least 12 different witnesses, I think, that have been interviewed. A handful have been given depositions, interviewed by staff, lots of different statements being made. All of those things have not made it into the press. They may, it's all public record, and they have the opportunity to do it. But I'm talking about in the real world, in real life, and the real world and real life is going to be what appears on Facebook and what gets onto TikTok and what is weaponized. And the risk here is the weaponization of the work of the committee being directed at the Congresswoman for political reasons, all of which, arguably is fair game in politics, right? Like, it's a contact sport, and I get it, and all of that is fair. But it's not okay if it violates her constitutional right to a trial. And we can expect that all of that is going to take place. So if the question is, well, if not now, when? My answer to the committee is as soon as possible. As soon as possible, without interfering with the member's constitutional right to a fair trial.
So
go ahead, I'm sorry.
So if the trial just continues, you've done this a long time, would you have some kind of reasonable prediction as to when there would be an appropriate time, other than from a chronological standpoint, other than when it ends? Because you could be a party of continuing it as well.
Right. So if I understand the question correctly, I think that the trial is likely to begin maybe the end of the summer or early fall, as the chairman said. I think the trial itself is probably expected to last a couple of weeks, would be my guess. And that's when it would be resolved. So really, I'm not talking about years, I'm talking about a matter of months in order to protect a constitutional right. So, on the one hand, you have this not just a desire, but a goal, an appropriate goal, to get this resolved as quickly, as expeditiously as reasonable, right? And as appropriate. On the other hand, you have a member wanting to protect their constitutional rights. And their attorney, their criminal defense attorney, is coming to you and saying, look, This is a problem. It's a problem because a lot of the things that are in the press, for example, would never be admissible in federal court. But that stuff is out there, and this committee's work is putting a spotlight on all of it. Yeah, it's out there in the public arena. I agree, Ranking Member, but not the way it will be if this committee starts issuing rulings and making decisions on things like summary judgment motions. Then it's a whole different ballgame. So, I think at the end of the day, we're talking about asking you to stay this for a matter of months. And I understand the desire to get it completed. But let me ask the members of the committee, do you go through all of this angst when the Department of Justice asks for a deferral? Because it seems to me that when the Department of Justice walks in here and says, don't talk to any more witnesses, staff immediately agrees. Or when the Department of Justice walks in and says, we're going to stay this, we want you to stay this matter until our criminal case is resolved, the committee immediately agrees. I'm not saying if it's right or wrong, I'm just saying that's what happens. And if we give such deference to the Department of Justice, why aren't you giving the same deference to a member of Congress? The executive is not a more powerful branch of this government than the House. They're co-equal branches. And I would respectfully suggest that if we're going to allow the Department of Justice to decide when these hearings take place, well, then we should be concerned about the committee member as well. Basic fairness.
I just conclude, from my perspective, that's a mischaracterization. We don't let the Department of Justice to decide, and that's what you're arguing, as I hear it. That's the precedent, and there's a reason for that. I yield back.
The ranking member yields back. Ashley, any questions? Glenn, any questions? Yes. You're recognized.
I don't know if this is on. Okay. Okay, Mr. Barzee, a couple questions for you. When we were talking about this, I guess it was last week, and you talked about needing 6 additional months. Is that a different time frame than what you're talking about today, or was it for a different issue?
It's a different issue. I think it's got a little confused.
Okay.
So
what was the 6 months referencing?
that was a reference to how much time I would want if I was taking on this case and I had to come in and argue it. And I was saying, well, I would want at least 6 months in order to review hundreds of thousands of documents, interview the witnesses that needed to be interviewed, and be ready to prepare for an adjudicatory hearing.
Okay, but it's not 6 months now, if I'm hearing you correctly.
No.
I think you're saying, okay, so then the request you're making is to delay, I guess, the motion for summary judgment until after the trial is over? Is that right?
Right.
Let me give you a hypothetical. Let's say the
Yes,
judge sets the trial date. Well, actually, before I do that, on when he sets the trial date, have you had additional conversations with the Department of Justice about when a trial date might be set since
sir.
we last talked?
No, sir.
No. Okay. So let's say the Department of Justice and you all and the judge agree to say it 6 months. They set it out in, November or something along those lines, or perhaps later. Would your request be to delay the motion for summary judgment until after the trial? And by the way, the Fifth Amendment right doesn't extinguish with the trial. It would go to sentencing if I read your motion correctly. So would you want the trial, 6 months for the trial date, and then the sentencing date, which could be 2 or 3 months after that, before we would have the motion for summary judgment? Or would you be amenable to doing something sooner than that?
Something sooner, absolutely 100%. As soon as the criminal case, the issue of guilt or innocence is determined by a jury, as soon as the jury's work is done, we would be completely 100% ready for the committee. So
right.
we're not asking for a delay until sentencing or appeals are extinguished or anything like that.
Okay.
It's just until the jury's work is done.
Okay, fair
Because
enough.
that's what we have to
Let me ask the
protect.
next one before I run out of time. So, no offense to you. We
No,
just have a
you got it.
5-minute clock, that's all. So, with respect to the Fifth Amendment argument, one of the things I would want you to do, if we get to the motion for summary judgment, is to explain where the Fifth Amendment issue would arise. In other words, and I know you raised it, I just had this time to skim through your motion, so you raised it a few times with respect to creating a, issue with respect to dispute with respect to material facts. But I'd want you to tell me how that is, and we don't need her to testify. You want to keep her, I get it. You don't want to put her in a Fifth Amendment exposure scenario. But I would at least want representations about what it is that she would say, or what is that Fifth Amendment issue that would arise. And the other part I'd want to know about that too is whether you can raise it through additional witnesses or documents. You attached some documents here. I haven't had a chance to go through all of them. But I'd want to know why you can't raise some of those issues just for the disputed material fact piece. We're not talking about a full-blown trial. Just for that piece, why can't you tell us that? And then the last part I would ask on this, and actually for committee counsel, why not give them the same deference that arguably we give to the Department of Justice with respect to these kinds of issues? Department of Justice, and we don't always just agree to what they request, but are we giving the same kind of deference to the member here that we would with respect to the Department of Justice under similar kinds of circumstances?
I'll take the question for committee counsel first. First, as a initial matter, the committee does not always defer at the request of the Department of Justice. That's not just recent precedent, but precedent throughout the years. Secondly, as to the question of why not to provide deference to respondents when they seek the committee deferral, the committee has sometimes stepped back, not just at the request of a respondent, but in recognition of the Fifth Amendment concerns when there is a brief, non-dilatory proceeding, like when a member is arrested for drunk driving or something like that. But this is a complex matter that has gone on for many years. And what's unique about this case versus many of the other matters where the committee did defer at the request of the Department of Justice is that in many of those other cases, the allegations came to light because of the indictment that the Department of Justice released. But the committee's investigation predates that of the Department of Justice. The committee has a truckload of evidence relating to a sitting member of Congress, and those same TikToks that are inundating the jurors of South Florida are affecting the American public's view of this institution. And so it is a live question now.
I've run over, so I yield back.
Nathaniel, any questions?
Yes, thank you, Mr. Chairman. I've got a couple questions for you, Mr. Barzee. I want to go back to the second question that the chairman posed to you that I don't think you answered. You artfully avoided answering that question, and that is this: under what circumstances, if any, do you believe this body can move forward with an adjudicatory hearing while there is a pending criminal case? I thought I heard you basically say there is never that circumstance because of your perceived or your argued imposition on the Fifth Amendment right of your client. Is that correct?
That is correct. It's not just for the Fifth Amendment right, but it's also because of the risk of tainting a criminal jury.
So you would say to this body, anytime there is a criminal proceeding for any individual that has an ethics complaint in Congress, a person that has voluntarily submitted to those ethics rules and this body's jurisdiction, you would say we must hold off pending the resolution by a jury of a criminal case. Is that what you would argue?
I would suggest to the the committee that if you are dealing with allegations that are essentially close in nature to the allegations in the criminal case, the most prudent thing for this committee to do would be to stay its proceedings until the criminal case was resolved.
Okay, you've softened your answer a little bit because now you're saying it's a matter of prudence, not constitutionality. I want to go to the one case that you cited for us, which is a Western District of Kentucky district judge saying we should hold off. That was your argument. That's what you've cited in your motion to reconsider. Would you agree, number one, first of all, we're not subject to the jurisdiction of the Western District of Kentucky. That's should be plain and easy for everybody to understand. Because they are a separate branch of the government.
That's right.
Number two, there are lots of federal civil cases that we could cite in opposition to say, look, many other judges, and I've been involved in some of those cases, would say, despite the fact you have a pending civil case, under the same factual scenario as a criminal case, we should proceed with the civil case. Would you agree with that fact?
Absolutely, 100%. Yes, sir.
All right, that's all I need. Yield back.
Yields back. Sylvia?
Thank you, Mr. Chairman. I don't think this is working.
That's working.
It's working now?
Yeah.
Good. Mr. Barcy, I just want to ask you, what has changed since last week that you're asking us to reconsider? I mean, what has changed since the first decision?
Why I'm asking the committee to reconsider its previous.
What new facts, what has happened, what has changed that you're asking us to reconsider?
I'm sorry, can I have one moment, please?
Sure.
Well, one of the issues was that I'm not sure we raised initially was the committee's rule about only going back for 3 years when you're investigating the violations, and that was something
I'm not
that
familiar with that rule.
I'm sorry?
I'm not familiar with that rule. I'm new to the committee, so can you hold a minute, Mr. Committee Counsel? Is that true? Do we have a rule of 3 years?
That's not accurate. There is a effectively statute of limitations that says that the committee's investigations can go back to the third previous Congress. So functionally, that is through 2019, long before any of the conduct at issue here. I don't know why it's relevant to the motion at issue.
So how is that relevant, sir?
The reason it's relevant is it's the rule is 3 prior Congresses. So I want to make sure that this committee understands that we're not attempting to run out the clock. So one of the things that we did in the motion to reconsideration to answer the question as to what has changed is we are affirmatively saying we're not trying to run out the clock. If there is a statute of limitations, if you can only go back 3 Congresses, we will waive that. We're not, this is not about us getting to 0-0 on the time clock. We want this matter resolved. We want to come in here and have this matter resolved.
So you don't have any new evidence or anything to support your motion for reconsideration?
I don't have any evidence to present at this time. No, I do not.
I want to follow up on some of the questions Mr. Ivey asked about the Justice Department deference. What makes you think that we automatically do whatever the Justice Department does?
My Irish passion sometimes gets ahead of me. It seems when you're looking at the record that when the Department of Justice in the past has asked the committee to defer, the committee seems to be willing to defer at the request.
But you say seems is.
Well, I don't know what the committee members'
So it's
thoughts
just
are.
So it's just your personal opinion?
No. It's, I apologize. I didn't mean to speak over you. No, it's not my personal opinion. It's if we go back and look at how many times the Department of Justice has asked the committee to defer, it is my belief, based on the historical precedent, that this committee often defers at the request of the Department of Justice. I think that's factually correct.
Move on to one last question because, as it's been pointed out, we're working against the clock.
Understood.
You you also kind of threw out there that you needed more time to review documents. But you haven't asked for a continuance to do that. You want a whole stay on all the proceedings until after there is a conviction.
As I pointed out previously, there's really two different issues. The one issue are the
So you're not
constitution.
asking for a continuance.
I am, and I will. I will now ask the chair and ask the committee to continue this matter in order to give me enough time in order to answer thoroughly the motion for summary judgment, in order to give me more time to review the work that staff has done in the case. I have been representing this Congresswoman for 2.5, 3 weeks. And I would pray that everyone on this committee, God forbid anyone ever needs a lawyer, you want your lawyer to be prepared. You don't want them doing it off the cuff.
Well, we want you to be prepared, but we don't want to face a new lawyer every time we have a hearing asking for a continuance because they need time to prepare. And I believe this is what, the third lawyer or the fifth lawyer? Fourth lawyer?
Understood. And it's a very, very valid concern, and I get it.
So how much time are you asking for, sir? 30 days, 60 days?
For the beginning of June, I would request.
How long is that?
Yeah, 60 days roughly.
60 days?
Yeah. Yeah. I'm saying the beginning of June only because I'm aware of your procedures about having hearings within a certain number of days of an election, and I believe our window closes.
Are you the lawyer in the criminal matter also?
Yes, that's how I became involved.
Okay, thank you. I yield back.
Brad, any questions?
Just briefly, I want to talk about, you've stated fairly authoritatively about how this would violate your client's constitutional rights, but that's a fairly broad statement in numerous respects. Would you not agree?
Absolutely, 100%.
If we proceed in this and we deny your motion, that is not at all a denial of her constitutional rights. That's your opinion, but that's not at all established in precedent by any means. I mean, we're not in a court of law. We're not dealing in a criminal matter. We are a body that's unique unto itself. We're dealing with rules. We're not dealing with any type of criminal adjudication. So I want to just push back on that a little bit, that we are not violating her constitutional rights if we deny your motion to continue this.
I would agree 100% with the member. And that's really what I'm saying is the actions of the committee will result in a loss of her constitutional rights. I'm not saying that the members of this committee are personally responsible for violating her rights.
So should an Article 3 court preclude this from going on?
An Article 3 court wouldn't have authority to preclude
Well, if we
this.
violate her constitutional rights, that would.
You're not violating her constitutional rights. You're exercising your rights,
Yeah.
right, for the House.
Right.
But in exercising those rights to an expeditious hearing,
Sure.
you are putting her constitutional rights in jeopardy.
So I disagree with you fully.
Okay?
I mean, if that were the case, an Article 3 court whose duty is to protect the constitutional rights would have the right to stop this proceeding. And I disagree that forcing us to go forward under a rule, not a law, under a different evidentiary standard, not proof beyond a reasonable doubt, that her rights are not violated.
I appreciate your opinion. I disagree with it completely. And I'm not saying that you are the one who is violating.
This committee would if we decide to go forward.
Well, let me reframe it. What I am saying is the actions of this committee will result in a loss of her constitutional rights because it will be impossible for her to have an impartial jury if
Well, that's what I want to talk to
everything
you
that
about.
happens here.
That's the second part I want to talk to you about. You would stipulate there are criminal trials that have received far more coverage, far more attention, far more slanted receipt from the public than this if she were to go to trial, correct?
Not when a committee of the House,
You wouldn't stipulate that?
not in cases where a committee of the House of Representatives declares guilt or innocence. This isn't about pretrial publicity.
Talking
This
about
is
rules, not crime, but it's your testimony or your argument that if we go forward, that will be the most prejudiced of any jury trial in a criminal context.
What I'm saying is if you go forward, any decision that this committee makes, for example, this committee says we find you in violation
Of rules,
of rules.
correct.
I know that the member is a lawyer. I know that the member worked in the prosecutor's office. I get it.
And I saw defense lawyers every trial advocate for limiting instructions, motions in limine, motions to exclude evidence. There were cases that had dozens of press releases, interviews, arguments that fit exactly within what you're saying. And it's the job of the court and counsel to ensure that juries only consider what? Evidence presented in the trial, not what we decide here. Is that correct?
Most respectfully, they're not robots. We're talking about
No,
human
I'm just asking,
beings.
is that correct though?
Yes, everyone tries to give someone a fair trial, and that's what judges are supposed to do, and I appreciate that. But prospective
that's
jurors aren't robots. If they hear that she's already been found guilty, how can she have a fair trial? This isn't about pretrial publicity. This is about the House of Representatives passing on the same issues that a prospective juror is going to be deciding.
She would be found in violation of the rules of the House, not the law. There is a very real distinction there.
And do you think
I hope you would submit that. Agreement.
Absolutely. And do you
Okay.
think the press is going to follow your admonition and say that she was in violation of a rule of the House? Or do you think the press is going to say, Congresswoman guilty?
Candidly, that's the job of the defense counsel to ensure that standard's met.
I agree with you, sir.
Yes, sir.
And I'm doing my best.
You are. You're doing a great job. I yield back.
Gentleman yields. Suhas.
Thank you. Thank you, Mr. Chair. I just want to ask one other question based on something you brought up. You mentioned the tainting of the jury pool. Wouldn't you be able to, through voir dire, be able to sift out any jurors who might be biased from anything they may have seen in the news?
Absolutely. I mean, that's one of the safeguards that the member from North Carolina was pointing out. There are safeguards, and I would be able to theoretically, if the federal judge allowed me to, I would be able to voir dire members of the panel about what they heard. But my point to you is that let's be real. All right, let's not try to say, well, this is a violation of a rule as opposed to a law. Let's talk about what people are going to understand. And yeah, a prospective juror who sees on CNN the banner that she's been found guilty by the House of Representatives, yeah, maybe that juror comes into court and says, yeah, I won't consider that. But it's there. It's on their mind. It can't not be. If I asked everyone in this room right now not to think of a pink elephant, guess what everybody's thinking of right now? Pink elephants. We're human
I think
beings. We're not machines.
Your point's taken. Thank you. Thank you. Do you have any other points you want to make? I think we heard a lot of this last week, actually, but I want to give you some time to make any new points or additional points you haven't made.
Thank you. The additional point would be the request for a short continuance in order to give us more time to develop a response to the summary judgment motion. We filed something at the last minute, but it is not what the Congresswoman deserves. She deserves to have lawyers working on that for a while and to present a solid answer to the committee's motion for summary judgment. So at the very least, I would request a continuance until June so that we would have time to respond to that motion.
And
Thank you,
committee
sir.
counsel, do you have anything else to add?
I'll just note that with respect to the Fifth Amendment's application here, it is not a settled matter that the Fifth Amendment would bar a parallel proceeding such as this one. There are matters where adverse inferences are drawn in civil proceedings all the time, whether it's a Securities and Exchange Commission matter or a divorce proceeding or anything like that. There are a lot of matters that need to run in parallel to criminal proceedings. What's unique here is that this is a matter that also involves a distinct branch of government with its own mandate. I'll also note that this is not a matter where we are suggesting the committee draw adverse inferences, but that it work with the record it has before it to meet its obligations.
I yield back. Thank you.
Gentleman yields back. We've had a request for one additional question from Mr. Ivy, and then Ms. Henson wishes to make a statement. So Glenn, you're recognized. You go ahead.
Okay. Thank you to both of you. I want to see if I can tease out where we are with respect to the stay versus continuance. So the stay, I think we've kind of argued past that because just the length of time and the issues that are raised with respect to the Fifth Amendment challenges and the like. The continuance piece, though, let me ask why do you need additional time? And I want more specific than there's a lot of documents out there and I need time to go through them. What exactly would you like to try and do to address the issue with respect to disputes with respect to material fact that would be relevant to the motion for summary judgment? What exactly are you trying to do? And how little time could you do that in?
Thank you, sir. The very first thing I would do would be to sit down with my client and come up with a list of witnesses to interview, to offer.
I don't want to get in your attorney-client privilege
Okay.
piece, but I bet you've done that already, right?
No, I haven't.
Haven't had a chance to do that with her?
So we've
No.
been, I've had the case for 2.5 weeks. We have not arranged for witness interviews.
Not witness interviews, but just with respect to talking with her about what time. Okay.
No, we've talked, but I need to get people into the office. I need to set up interviews.
All right.
We need to work on the case. We need to go through the documents and prepare responses. None of that has been done. Not really.
All right. And
We
then-
did our best in 2 or 3 hours to put something together, but she deserves a real response to this motion. And in order to do that, it's going to take time.
Okay. And then the documents that you did attach to the motion you filed, I think these are the documents you attached. Can you tell me briefly what the relevance? You got an affidavit. I saw a notice of a settlement agreement, if I recall correctly. There was a document on there that was too small to read for an old eyes like mine. What are the points that are raised in those documents that would be relevant to the motion to dismiss?
To the summary judgment motion.
Yeah, I'm sorry.
Yeah. First, you have an affidavit in there that is contradicting evidence that staff was relying on in their summary judgment motion, saying that that did not happen. I was a witness to that, and I saw it differently. So that is a conflict in
What is the that?
the specific disagreements.
I mean, it doesn't have to be all the way in the weeds, but give me a general sense of what the disagreement is.
Disagreements about why money was moved, for example, from one account into another, how loans were made, who was responsible for directing those transfers of money. You have staff has a witness who's claiming that the Congresswoman purposely put money into an account and then withdrew it in violation of FEC rules and regulations. And my understanding is the witness is going to say that that's not what happened. The congressman never directed that for it to happen that way. It was done by another individual.
Is that the affidavit or is that?
That's the affidavit. I mean, I mean, to be honest, this is part of this is just having the case for 2.5, 3 weeks.
I'm not trying to pick it apart. I'm just
Yeah.
trying to figure out what what the documents were and the relevance of those
Well,
to
The-
the motion.
Yeah, the other things that we attached was the fact that many of the complaints that have been alleged by staff were also investigated by the FEC. And they had to do with the fact that this was the Congresswoman's, for example, the most recent ones, maybe her first successful election, and having volunteers handle things like financial reports and not having a professional compliance team on board. So lots and lots of different mistakes were made, and a lot of those mistakes are reflected as complaints of the violations. The information.
That's the settlement agreement, the FEC settlement?
There was a settlement agreement where the FEC referred the Congresswoman to alternative dispute resolution, indicated that she needed to hire professional compliance staff in the future, that somebody had to undergo remedial training on the necessity to file certain financial disclosures, all of which has been done.
Okay, and then that document that you have there is some kind of it's too small for me to read, but it was like a spreadsheet. What is that?
It's huge. That's the most important document, and that's a document that unfortunately touches upon the criminal case, which is one of the reasons why it's troublesome for me to get into it. But one of the major allegations that staff has made is that Trinity Health Care Services funneled money illegally into the Congresswoman's campaign, and that the Congresswoman was just taking money from Trinity and using it for her campaign. Nothing could be further from the truth. One of the things that we filed so that the committee has it in front of them is the fact that she was entitled to a certain percentage of profits of Trinity, and the money that she was receiving from Trinity was not money that Trinity was using to finance her campaign. It was money that was legally obligated to be paid to her as part of the profit sharing agreement. And those are the documents that were presented.
And I know I appreciate the indulgence of the chair. Could I ask counsel for the committee to respond to what they've heard? By all means.
I think much of what Representative Cherfilus-McCormick's counsel has raised goes towards the motion to summary judgment, and we're happy to address it in that context. To the extent that he is raising a new motion seeking some additional time, a continuance of a couple weeks, while that is procedurally improper, we're not objecting to him raising that now. And we wouldn't object in theory to the idea of a little more time, but we would raise some concerns about that concept. It's a little unrealistic given the realities of the House calendar and scheduling things. And then the blackout period that's been referenced would start in, I believe, around June 24th, 60 days prior to an election in which the respondent is a candidate. The process that we're undergoing is more than just one day. This involves a adjudicatory hearing at this time, but provides for a sanctions hearing to follow, and then likely a resolution for the entire House to consider. I think that the reason why we are here now at this time is because this is what puts the House on track to consider this in a timely manner before that blackout period begins.
Thank you, Mr. Chair.
Gentleman yields back, passed over. Ms. Henson, you have 5 minutes to ask questions or make a statement.
Thank you, Mr. Chairman. I just want to make a quick statement. In council's opening remarks about the motion, it was implied that this is being done for political reasons. And I just want to say, and you said that earlier today, I want to be very clear that this committee is about respecting the integrity of the House. It's not political reasons here. You have an evenly balanced Republican and Democrat rostrum here, and I think it's very critical that we clear the air there and make sure that it is on the record that this committee is about respecting the integrity of the House. Do you dispute that you said that earlier? Because I wrote it down when you did.
If I did, I withdraw that. I did not mean to make that statement about the actions of this committee. I was not at all suggesting that this was some kind of a political vendetta against a congresswoman, or that the Republican members of the committee were acting inappropriately in any way whatsoever. So I withdraw that if that was said. That's not what my intention was. My point was, we live in a political atmosphere, and of course, her political opponents, not meaning the Republican Party, meaning people wanting her congressional seat, are going to weaponize whatever this committee does against her. That was my point, not that the committee was acting inappropriately in a political way. I don't believe that to be the case.
Thank you for the clarification. I yield back.
Yes, ma'am.
Gentlelady yields back. I want to personally thank counsel for both sides for their arguments. Thank you for answering questions proposed by this body. At this time, the subcommittee, we will recess the hearing to allow us to move into executive session and to consider deliberations on this matter. Once we have reached a decision, we will return. So with that, the committee will stand in recess.
Well, I'm inclined to give it a little time.
The committee will come to order. As we return from our deliberations, it is the decision of the subcommittee that the respondent's motion to reconsider is denied. We will then move forward at this point with the motion for summary judgment. The subcommittee will now hear arguments from committee counsel for summary judgment. Because this is the council's motion, I will recognize committee counsel Sidney Belwer for arguments on the motion for summary judgment. And at the conclusion of those arguments, counsel for the respondent, Mr. Brazier, you will have the opportunity to argue on behalf of your client. So at this time, counsel for the committee, the floor is yours.
Thank you. Good evening, Chairman Guest, Ranking Member DeSaulnier, and members of the Adjudicatory Subcommittee. I am Sidney Belwar, Senior Counsel for the Committee on Ethics, and I wanted to take a moment to introduce the other staff who are here with me today: Brittany Pescatore, the Director of Investigations, Jen Seba and Ray Radican, who are co-counsel on this matter. And we are all part of the committee's nonpartisan and professional staff. Committee counsel welcomes this opportunity to make clear that the committee's investigations seek only to find facts, and based on those facts, determine whether there have been violations of any law or ethical standard. The Committee on Ethics is uniquely charged with protecting the integrity of this institution, and speaking on behalf of the investigative staff, we take this duty seriously. At this time, committee counsel would like to introduce the documents bait stamped ISC 000001 through ISC 016942 into the record under seal. Respondent has had access to these records since at least December 9th, 2025.
Mr. Chairman, I'm still having trouble hearing her.
My apologies. Committee counsel would also like to be heard on the motion for summary judgment that we noticed on March 6th, 2026. The motion before you argues that the facts relied on by the statement of alleged violations are uncontroverted and supported by the record, and that those facts are sufficient to find each count in the statement of alleged violations has been proven by clear and convincing evidence. The memorandum in support of the motion extensively cites the statement of alleged violations, which itself is supported by the voluminous record in this matter, including bank records, witness testimony, and contemporaneous text messages and emails. Respondent's response to this motion, submitted 30 minutes before the hearing was scheduled to start, argues that motions for summary judgment are not allowed in criminal proceedings. Notwithstanding that this committee is a civil legislative branch body, and the committee counsel submission is not a motion for summary judgment under the Federal Rules of Civil Procedure, Committee Rule 23-0 clearly contemplates this type of motion, essentially a motion to rule on the papers. Rather than putting on a trial with public examination of witnesses, we are here today to outline the information that you already have and answer any of your questions. Going back to 2023, respondent has had every opportunity to provide information about the allegations under review. Over the 2 years of its investigation, the investigative subcommittee conducted 28 witness interviews and reviewed 33,000 documents. The investigative subcommittee carefully considered this evidence that it had compiled in deciding what charges should be brought against respondent in the statement of alleged violations.
Sidney, let me interrupt you very briefly. The acoustics in this room are not ideal. And if you would please, I know you're trying, please speak into the microphone. Some of us are having a little bit of a difficulty hearing you. Thank you.
Yes, thank you, sir. Respondent received a copy of the draft statement of alleged violations, supporting evidence, and exculpatory evidence prior to the investigative subcommittee's adoption of the charges. And respondent had the opportunity to object to the evidence relied on in the statement of alleged violations, negotiate the facts and counts to be included in the document, or engage in settlement negotiations. She did not do so. Prior to today's hearing, respondent was again given the opportunity to object to the evidence relied on by the statement of alleged violations. She was also given the opportunity to provide notice of any evidence that she intends to present or witnesses that she intends to call in opposition to the notice motion. Respondent waited until less than an hour prior to this hearing to file a response in disregard of the already extended deadline granted by the adjudicatory subcommittee. Regardless, the submission does not raise any legitimate disputes as to any material facts. To the extent counsel attempts to introduce new facts to the matter at this stage, his representations are not evidence. The adjudicatory subcommittee has convened here today to consider whether the record established by the investigative subcommittee proves the facts and whether those facts are sufficient to prove each count in the statement of alleged violations. The 27 counts charged in the statement of alleged violations are as follows. Counts 1 through 7 relate to the improper receipt of funds by respondent's campaign from her parents' healthcare company, Trinity Healthcare Services, either directly or through conduits, and respondent's receipt of funds from Trinity to which she had no legal right. Counts 8 through 12 relate to the improper receipt of funds by respondent's campaign from other organizations, including political action committees, nonprofits, and corporations. Counts 13 and 14 relate to respondent's campaign's failure to file accurate reports with the Federal Election Commission. Counts 15 through 17 relate to criminal violations implicated by respondent's conduct with respect to funds from Trinity and a Florida-based company, Petrogas Haiti, as well as false statements. Count 18 relates to violations of House rules concerning commingling of personal and campaign funds. Counts 19 through 23 relate to respondent's failure to file certain required financial disclosure statements with the House and reporting errors contained in financial disclosure statements that she did file. Counts 24 through 26 relate to violations of House rules concerning special favors and acceptance of voluntary services by respondent's congressional office. Count 27 relates to respondent's lack of candor and diligence during the investigative subcommittee's investigation into respondent's conduct. Nearly all of these counts are charged as violations of the Code of Ethics for Government Service and the Code of Official Conduct. The Code of Ethics for Government Service requires those in and seeking to serve the government to uphold the laws of the United States and never be party to their evasion. The Code of Official Conduct requires members to follow both the letter and spirit of the rules and to act in all times in a manner that reflects creditably upon the House and applies to counts related to respondent's conduct after she became a member. In addition, each count describes the underlying laws and rules specific to the conduct enumerated in that count. A full recounting of the facts underlying each of these charges is extensively documented in both the statement of alleged violations and the memorandum in support of the summary judgment motion. The facts, which are supported by the record, show that respondent has attempted time and again to circumvent the laws and ethical standards to which she is subject. Fundamentally, the allegations before you involve a member of Congress misleading constituents, the FEC, and the House of Representatives in order to obtain and keep a congressional seat. Respondent won a seat in the House of Representatives after portraying herself as an independently wealthy nonprofit founder who self-financed her campaign. However, the record reveals that this apparent nonprofit, Essential Community Health, initially entered into a contract with the state of Florida regarding COVID-19 vaccinations in February 2021, despite making claims in its submission that were untrue. In fact, Essential Community Health was a sham, and the source of respondent's wealth was actually her parents' healthcare company, Trinity, which became a party to the contract instead of Essential Community Health. At that time, respondent had been the CEO of Trinity for years and had earned a salary of around $86,000 annually, according to her tax records. But in 2021, Trinity received over $14 million from the state of Florida pursuant to this agreement. More than half of that $14 million from the state of Florida ended up with respondent and her siblings. Publicly available records show LLCs owned by respondent and her siblings, SCM Consulting, EC Firm, and MC Nursing, were formed shortly after Trinity was awarded the COVID-19 vaccination contract at the beginning of March 2021. Their bank records show these companies had little or no other clients. Respondent, her siblings, and their LLCs did not enter into consulting contracts with Trinity, but did split the profits of the money Trinity received from the state of Florida. Bank records, Trinity's internal records, and Trinity's tax documents show that respondent received approximately $6.7 million from Trinity in addition to her annual salary. $2.3 million of that went to her directly, and $4.4 million went to her consulting company, SCM Consulting. She and her brother also received around $600,000 from Trinity in 2021 through EC Firm, which they co-owned. Hundreds of thousands more went directly to her siblings, their LLCs, and her close friend and District Chief of Staff, Nadege LeBlanc. Most of that money made its way to respondent's campaign. Some transfers of funds were reported as personal loans from respondent. Some were not reported at all, and many were reported with inaccurate amounts, dates, or sources. Respondent's
response argues, quote, "The record reflects that Trinity did not transfer any funds to respondent's campaign," end quote, but it did. Bank records clearly show that Trinity, a corporation, made direct contributions totaling nearly $200,000 to the campaign. In addition to the funds that flowed directly to the campaign, respondent and her siblings funneled more than $500,000 originating from Trinity into various outside organizations that made expenditures on behalf of the campaign. A candidate can donate her own money to her own campaign, but it has to meet the legal definition of personal funds. Respondent was aware of this as early as March 27th, 2020, when her campaign advisor explicitly told her. Nonetheless, during respondent's 2020 campaign, respondent reported a $50,000 personal loan that she did not actually make. Instead, just before the filing deadline, respondent received $50,000 from her husband's law firm and put that into her campaign account. Then she paid her husband back with funds from the campaign just after the filing deadline passed. In her successful election to the House, respondent repeated this scheme on a much larger scale. Bank records show a pattern of respondent moving money into and out of her campaign accounts just before and after the filing deadlines in the special election, misleading voters about the strength of her campaign. The most egregious example of this scheme is when, on June 23, 2021, Trinity transferred $2 million to the respondent, who transferred this money to her campaign the next day. Then, shortly after the end of the filing period, on July 2nd, respondent returned the money to herself, nearly in full. Respondent was also aware that there were limits on who could make contributions and in what amounts. In 2021, individuals could donate a maximum of $2,900 per election. In text messages to her campaign treasurer, respondent indicated that the contribution limit was why her sister gave money to her friend Nadege LeBlanc to give to the campaign, with Nadege acting as a straw donor to funnel additional funds originating from Trinity into the campaign. These schemes paid off, and after a recount, respondent won her election by 5 votes. Meanwhile,
Understand
Uh,
the exhibits are saying and how they connect to which count?
I would prefer, Mr. Ivy, if it would be okay to wait until after a presentation from both sides. But then we will have ample time for you and any other members that may have questions. So if you could wait till the end, let counsel for the committee make their presentation, counsel for the respondent, but then there will be ample time to ask questions, if that is okay.
Yes, sir.
You may continue.
thank you. Meanwhile, the campaign had also been paying respondent back for her loans, even though they did not all originate from her personally. Bank records show that respondent has received at least $2.8 million from the campaign since 2021. Between the transfers of funds for purported personal loans and loan repayments, as well as the numerous other discrepancies apparent in respondent's campaign bank records, respondent has made at least 60 filings with the FEC containing false and inaccurate information. After spending much of the funds obtained from Trinity during the special election, respondent found herself immediately having to run again for the 2022 election. Text messages show that respondent and her campaign advisors were concerned that she would be outraised in the first quarter by her primary opponent, who she had only narrowly beaten in the special election primary. Bank records and text messages show respondent again deliberately inflated her campaign committee's cash on hand through making and reporting a large personal loan to the campaign. The campaign reported receiving more than $1 million from respondent, when in fact, respondent transferred $400,000 to the campaign, and the campaign did not receive that money until just after the reporting period ended. It was also repaid a few days later, similar to the scheme used in her prior campaigns. In respondent's response to the motion, counsel asserts that, quote, "The record reflects that funds were available to satisfy campaign-related expenses from lawful sources," end quote, but that is inaccurate. The record reveals that respondent's 2022 re-election campaign costs were largely and impermissibly paid for by companies and political action committees run by her friends and family. According to bank records, the single largest source of funds that ultimately went to these organizations in support of respondent's re-election campaign was Petrogas Haiti, which itself was primarily funded by the Haitian government during the relevant period. Having demonstrated concerns about financing her re-election campaign, respondent had a meeting with the owner of Petrogas Haiti, arranged by the chair of her leadership PAC, Michael Joseph. A few days later, Petrogas Haiti started making payments to a newly created organization called Progressive People, Inc. Progressive People was created by Michael Joseph and respondent's husband, who served as the president and vice president, respectively. Petrogas Haiti gave Progressive People $810,000 in 2022, which accounted for almost 90% of funds that Progressive People raised that year. The majority of that money, $725,000, was passed on to a company called Truth and Justice, Inc., which was run by respondent's campaign consultant and spent nearly entirely for the campaign's benefit. At the same time, respondent and her siblings were also providing funds to Truth and Justice and to political action committees associated with the then president of the National Haitian American Elected Officials Network for the benefit of the campaign. Most of the arguments in response to this motion essentially suggest that there is insufficient evidence that respondent was aware that her campaigns were being financed through the very companies she and her family members were funding. That not only strains credulity, but is belied by the numerous contemporaneous emails that she is copied on regarding coordinated expenditures or messages with her campaign staff about varying payment sources. Candidates and members are also required to file financial disclosure statements with the House. Respondent was as cavalier as she was with her campaign finance reporting with the accuracy of her required House filings, if she filed them at all. The record demonstrates that respondent knowingly did not timely file her required candidate disclosure statements for several years in which she qualified as a candidate. In an email to respondent from her campaign advisor sharing press coverage of her delinquent filing for the 2022 special election, he noted that, quote, no record can be found of a candidate who is not yet a member being disciplined for withholding the required pre-election disclosure, end quote. With this knowledge and her campaign's funding already under media scrutiny, respondent intentionally waited to disclose her finances until after she won her competitive primary. The evidence also shows that respondent has not filed full and complete financial disclosures since becoming a member of Congress. As a member of Congress, respondent has brought the same disregard for the rules to other ethical standards applicable to members, accepting volunteer services from a campaign advisor, including for franked communications, and using her position to benefit her allies with special favors during the appropriations process. Around the time that he was setting up Progressive People, respondent's friend and leadership PAC treasurer, Michael Joseph, was contacting respondent's congressional staff to pressure them to submit specific community project funding requests to the Appropriations Committee. When staff objected to some of the projects, respondent overruled them, including using one of the 15 slots for submissions on a project that one staffer had already identified as being ineligible. She similarly prioritized a community project funding request for a foundation associated with an individual whose company provided messaging services to both respondent's campaign and congressional office. In her response, respondent tries to create what her counsel deems genuine issues of material fact by alleging in some instances that respondent did not know better or was in the dark about what her closest advisors, family members, and staff were doing. But in almost every instance, counsel has argued that respondent's knowledge was not material to the charge. Rather, it was how her campaign or congressional office operated, which are organizations that she's ultimately responsible for. Finally, the record reflects that respondent did not meet the level of diligence and candor owed to the committee by respondents. Respondent was given every opportunity to address the allegations in the investigative subcommittee's 2-year investigation. Respondent received 3 separate requests for information, which were ultimately narrowed to reduce the scope and burden. She also spent several months considering and ultimately agreeing to a voluntary interview, only to cancel 2 days in advance. After multiple assurances of continued cooperation, followed by no meaningful progress, leading to significant delays in its investigation, the investigative subcommittee felt it was necessary to authorize subpoenas to respondent for her testimony and documents. Respondent has a Fifth Amendment right not to incriminate herself, but she wasted valuable time and committee resources in feigning her cooperation. Since this adjudicatory subcommittee has been established, respondent has likewise flouted the deadlines established by the chairman and ranking member, including making an untimely response to the instant motion less than an hour prior to this hearing. Any evidence in that response could have been provided at any time during these proceedings, and indeed at any point during the investigative subcommittee's investigation. With that said, committee counsel welcomes any information of actual relevance, and we are prepared to answer any questions the adjudicatory subcommittee may have, including regarding respondent's last-minute submission. Committee counsel submits to you that no dispute of material fact exists related to this motion, What does exist is a mountain of evidence showing respondent violated applicable laws, rules, and ethical standards. For these reasons, and those stated in the memorandum in support of the motion for summary judgment, Committee Counsel urges the subcommittee to find each of the 27 counts in the statement of alleged violations have been proven by clear and convincing evidence based on the record before you. Thank you.
Thank you, Mr. Barzee. You're now recognized to argue on behalf of the respondent.
Most respectfully, the idea that staff is asking this committee to grant a motion for summary judgment, knowing that she is disputing all of the facts that they are alleging, knowing that her prior counsel has in writing indicated that they dispute these facts and these allegations, should tell you something. I have my client on the one side of me saying, that's not true. I want to get up and I want to testify and I want to explain something. I have to advise her not to, because I have to protect her Fifth Amendment rights for the criminal case. And on the other side, I have staff attorneys running through a litany of facts, all of which have been contested by prior attorneys with their knowledge. They've denied all of these allegations. They've stated that the Congresswoman is not guilty of these violations. I mean, listen, if the committee is going to take action, at the very least, you have to give us a hearing. You have to allow me to call witnesses on her defense. You have to let me cross-examine witnesses that staff put up. You can't just decide this on the paper and push it aside. I need to be able to see witnesses. She has a right to confront those witnesses. I have to be able to cross-examine people. We do not accept the facts as they are alleged by staff. And we've tried to do that in the best way we could at the last second. I'm not going to go through the request for more time, but this is the problem that we're in right now. And what I would suggest to this committee is the idea of just deciding all of these issues on summary judgment without giving me an opportunity to cross-examine witnesses, without giving me an opportunity to put witnesses on the stand, without giving me an opportunity to have enough time with the Congresswoman to discuss who else could be a witness that I'm not even aware of yet. I mean, these are the things that have to happen. This is what, and I understand it's a different branch of government, but this is what Article III courts refer to as due process of the law, meaning we don't railroad people and we don't decide things before there is a full hearing, before everyone gets a chance to say something. I'll give you an example. One of the documents we filed, and yes, it was filed late, and I apologize for that, but one of the documents we filed is proof beyond any doubt whatsoever that there was a profit-sharing agreement at Trinity, that she was entitled to every single penny that she received from Trinity, that profit-sharing agreement predated everything that happened in this case, predated the wrong payment that the state of Florida made to Trinity. So this profit-sharing agreement in and of itself is enough to defeat the motion for summary judgment, because it shows you that there are material facts that are in dispute. The Congresswoman does not concede at all the idea that she received money from Trinity, that she was, I think the wording in staff's paperwork is not entitled to. That's an absolute fact in dispute. And I would urge you to allow me to call witnesses that can testify about this profit-sharing agreement, call witnesses that would be able to testify that the Congresswoman was entitled to each and every penny that she received from Trinity. The other factual disputes are set forth in the affidavit that's before the committee already. I mean, this is just scratching the surface, but you can see how obviously the Congresswoman has disputed all of these allegations and all of these facts. This affidavit points out that the Congresswoman had basically no involvement with working out those financial disclosure forms, that other people in the campaign were dealing with that wasn't her responsibility. This is what the affidavit says. I attest there are several matters referenced in the statement of violations that were solely controlled by individual one, as opposed to the respondent, and to which the respondent did not have knowledge. So if she didn't have knowledge of something, if she didn't have knowledge that a financial form that was supposed to be filed wasn't filed on time, and the Congresswoman has no knowledge of that, and this is her first rodeo, is this committee really going to just decide that she intentionally violated finance campaign law? That would be a travesty of justice if that were to happen. Without calling witnesses, without giving me an opportunity to cross-examine someone, without giving me an opportunity to put a witness on the stand to take responsibility for some of this. She says, the person who fills out the affidavit said, regarding campaign operations, individual one made 95% of all strategic decisions. The respondent's involvement was limited to expressing general preferences or needs. The respondent was rarely present in the campaign office and did not participate in administrative or financial tasks. So put aside your beliefs as to what happened. Just procedurally speaking, that statement in the affidavit, if true, should be enough to cause this committee to say, you know what? Let's have a hearing. You want transparency? You want the public to know exactly what happened? There's only one way to do that, members, and that is for you to allow us to have an adjudicatory hearing, allow me to cross-examine witnesses that are saying things about the Congresswoman who aren't even here right now. How would that possibly be fair? I understand that the committee is frustrated because of the Congresswoman has gone through multiple attorneys. I get that. And I understand that staff is frustrated because the Congresswoman didn't show up for their interview and didn't comply with all of their requests. I understand that. And you know what? You can punish her for the delay. You can punish her for not speaking to staff when she said she was going to. But by gosh, at least give her a fair shake and let me cross-examine some witnesses. Let me put some witnesses on the stand to defend her and to tell you what happened. If the committee really wants the truth and you really want transparency and you want to get to the bottom of all of this, let me call somebody who will explain to the committee that every single penny she received from Trinity Healthcare, she was entitled to. The entire complaint reads as though Trinity Healthcare was pouring money into the campaign, right? That's what the alleged violations say over and over and over again. Well, that's a factual dispute because our argument is that Trinity was paying the Congresswoman her percentage of profits that she was entitled to. And what the Congresswoman decides to do with her own money is up to the Congresswoman. And if she wants to put money into her campaign as a loan, as far as I understand, she's allowed to do so. But you know what I would like to do? I don't want to testify. I want to call a witness. I want to call someone who can explain to the committee what exactly occurred with the finances and how she put the money into the account and when she put the money into the account. The record reflects competing evidence regarding the respondent's entitlement to the funds. There's a genuine dispute concerning the nature, authorization, and intended use of the funds at issue, as well as the respondent's intent which would absolutely preclude this committee acting on summary judgment without having a full public hearing so everyone knows exactly what the witnesses are going to testify to. The terms of the agreement that the Congresswoman had with Trinity, including her hourly compensation and profit sharing, are all reflected in contemporaneous communications, including the document that I earlier submitted from March 5th, 2021, which shows the projected financial report for Trinity and the administrative costs. The affidavit you have in front of her says that she relegated the authority to fill out all of the financial disclosure forms and do all of the reports to someone else in the campaign. Now, maybe that was a mistake. Maybe she should have been using professional compliance people to do all of her money. I would agree with that 100%. But the question is whether or not her personal acts were in violation of these House rules or reflects poorly on the House. The only thing it reflects poorly on is perhaps her managerial expertise in hiring the people that she hired. Because according to the affidavit in front of you, according to the documents that have been submitted, there are serious disputes as to what happened in this case. And the Congresswoman, by no means, by no stretch of the imagination, agrees with the facts as they have been presented by staff. Right. It's okay. The issues as far as the FEC are concerned that went to the alternative dispute resolution and were resolved by the FEC are another evidence that we disagree with staff as to the facts, as to the level of malfeasance that arises as a result of the poor paperwork and the poor financial reporting that was done by the people that her campaign hired. We acknowledge, and I acknowledge right here that many mistakes were made with her campaign and the way they reported the funds. There's no question about that. But that's as far as the agreement between us on the facts goes. After that, you have a complete disagreement as to what occurred. And in order to get to the bottom of that and make a decision as to who's telling you the truth and what actually happened, there's only one way to do that. And that's having a trial or having a hearing and calling in witnesses and questioning them under oath and giving me an opportunity to cross-examine witnesses that are claiming falsely that the Congresswoman did something wrong. So if the committee is not going to stay these proceedings until the criminal case is resolved, which would give me an opportunity to allow the Congresswoman to address the committee, if you're not going to do that, and you're not going to grant me a continuance in order to respond to the motion for summary judgment, at the very least, now is the time to pause. Now is the time to realize that the community, that the public deserve to be able to hear these witnesses. And the Congresswoman certainly deserves the opportunity for me to be able to cross-examine witnesses that are claiming that she did things improperly when we have the evidence that it's not true. And the funds flowing from Trinity are the most important part of that. Because the funds flowing from Trinity to the consulting business, to the Congresswoman, all worked out ahead of time with a profit-sharing agreement. That's half of the violations are related to that. So you now have evidence in front of you that there was a profit sharing agreement in place. You have an affidavit in front of you saying that she's not the one who's making the financial decisions. Someone else in the committee is. You have her prior attorneys informing the committee that she disputes the facts as alleged and claims her innocence. So are you really going to deny her the right to defend herself in front of an adjudicatory hearing? Are you really contemplating denying her the right to call witnesses on her own behalf? Are you seriously contemplating the possibility that her lawyer wouldn't be able to question those witnesses under oath to test their veracity, to weigh their credibility? If we want the truth, let's hear the truth. Let's parade the truth for the public so everyone can see what really happened here. Please don't make the mistake of deciding this based on some documents and papers that staff put together, rather than having a full hearing and hearing from witnesses and allowing me to defend this woman. Thank you.
We'll now move into opportunity for members to ask questions. Mr. Barthy, you are aware of summary judgment. That is a procedure that is regularly used. That is not unique to this courtroom. And we see that happen in courtrooms across this country. And so for you to sit here and make the claim that we, the committee, is trying to trample upon the rights of your client, I take offense to that. For 2 years, and I'm going to defend the process, for 2 years, the committee has worked to gather documents. For 2 years, we've tried to get documents from your client. Not only have we requested documents, but we have subpoenaed those documents. Those documents were not provided. For 2 years, we tried to get a statement from your client, even going to the point of issuing a subpoena. She does not have to talk to us. She can exercise her Fifth Amendment rights just as she did. But for you to allege that all of this information is new, that we've not tried to gather this information for the last 2 years, I find that offensive. And I'm personally offended because I know the work that this committee goes to protect all members and to make sure that we go above and beyond to make sure that there is fairness. And in this motion for summary judgment, you have had the opportunity to call witnesses. You can call witnesses. No one has prevented you from calling witnesses. We've allowed you to enter documents as exhibits to your response to the motion for summary judgment. And so for you to claim that we are doing something that is improper, that is wrong, we are following the same procedure that this committee used 16 years ago in the Rangel matter. We are following a procedure that we see happen in courtrooms across the country each and every day, where there are disputes as to the facts, but motions for summary judgment are one way short of a trial in which those facts are decided. And that is how the committee is following this process. We are not trying to circumvent your right to call witnesses. We're not trying to prevent you from being able to present documents to this adjudication subcommittee. And you have the opportunity to present documents, which you have. You had the opportunity to submit a response, which the committee accepted late. You have the opportunity, if you wanted to call witnesses. And so for you to make the allegation that we as an investigative subcommittee are trampling upon some sort of rights of your client, I take offense to that. And I just wanted to make the record clear that we as a committee for 2 years have looked into this matter. The investigative subcommittee has, that we've been now on their fourth attorney, that every time we talk to attorneys and every time we try to get documents, every time we try to allow them to present us anything that would tend to contradict the facts that the committee has gathered, we've not received that. And so again, for the record, you make a good record that your client just got an attorney, and and you make a record that this is a brand new proceeding, and that all this just happened and just began in January. But that is not what is laid out. The procedural history of this case is laid out in the PowerPoint 3 that was given to us by staff. Now, my question, staff, to you is looking at the PowerPoint, again, that addresses some of the allegations. Specifically, I want to turn your attention to the page 6 of the PowerPoint. Page 6 of the PowerPoint shows the flow of Trinity funds in 2021 and 2022. Now, going back to page 5, we see in 2020 that Ms. McCormick received a salary of $86,000 for her role as CEO of Trinity. Is that correct? Am I reading those documents correct?
That's correct.
And then in 2021 and into 2022, according to the documents and according to the PowerPoint, it appears to me that if you add the money that went directly to Ms. McCormick and the money that went to the LLC, which she exclusively controlled, which is SCM Consultants.
Mr. Chairman,
Yes.
can I give the Congresswoman's counsel a copy of this?
Yeah, I'm sorry if he does not have it. Yes, please make sure that he has a copy of the PowerPoint, and I apologize. Ms. Brazier, I'm looking at page 6 of the PowerPoint just so that you're aware as to the document that which I'm referring. It appears on page 6 of the PowerPoint that in 2021 and 2022, Ms. McCormick received $6.7 million in compensation. Is that what I understand? That the previous year she received $86,000, and the following 2 years she received $6.7 million?
That's correct.
And in addition to that, there was an additional $600,000 that went into a LLC known as the EC firm.
Yes, which she owned 50%
And
of.
Ms. McCormick owned half of those funds. And then from those different accounts, from her personal money that she received of the $2.3 million, from the SMC consultant, and then from the EC firm, much of that money then flowed into her campaign.
Correct.
And then there also seems to be money that came directly from Trinity Healthcare. Now, Trinity Healthcare is an Inc. It is incorporated, not an LLC. Is that correct?
It is an LLC that has elected to receive corporate tax treatment. So for campaign finance purposes, it is considered a corporation.
Okay. And according to document 6, and I think in the statement of alleged violations, it appears that $200,000 went directly from Trinity Healthcare into her campaign.
Nearly, it was about $198,000, a little more than that.
And would Trinity Healthcare have been legally able to give that money directly to the campaign?
No.
And then as it relates to the 2022 election funds, that is found on page 10 of the PowerPoint. I want to refer you to page 10 of the PowerPoint. It appears that the Haitian government deposited $12.5 million into a Florida-based corporation known as Petrogaz Haiti. Is that correct?
That's correct.
And then that Florida-based company, then they deposited $810,000 into a PAC known as Progressive People.
Progressive People was not actually a PAC. It was not registered as one, but yes, Petrogaz Haiti in 2022 transferred $810,000 to an organization called Progressive People, Inc.
And that organization, the respondent's husband was responsible, or was, it says here, owned by respondent's husband and leadership PAC chair. Is that
That's correct. Those two individuals own the organization and were on the bank records. The husband was the vice president. The other individual was the president.
And so then of that $810,000 that Progressive People received from Petrogaz Haiti, who received the money from Haiti, it then goes into I guess a third account, which is Truth and Justice.
That's correct.
And Truth and Justice was run by the respondent's campaign consultant. Is that what I understand?
That's correct.
And then money was paid out of the Truth and Justice campaign to pay vendors. So they went to pay for items that benefited Ms. McCormick's campaign. Is that correct?
Yes, that includes invoices explicitly billed to the Congresswoman's campaign that were paid by Truth and Justice.
It's the only questions I have at this time. I yield to the ranking member for questions of either council.
Thanks, Mr. Chairman. First to our council. The FEC settlement agreement, why is intent important? We all have to do these. We sign that we're personally responsible for it. Could you respond to that?
So to the extent there has been an assertion that the Congresswoman was not the one filing her FEC reports and was perhaps not aware of every FEC report that was filed, she is still the one responsible for that under the law, the rules and precedents of the House. There is also ample evidence that she was aware of at least some of this activity, most notably the millions of dollars that came out of her own bank account and others that she had access to.
And are you aware of, I am not, there are mistakes, naturally, with as many people running for Congress, but of this scale, it just seems sort of extraordinary.
No, I'm not aware of something on this scale. I mean, we have precedent where similar schemes were conducted and they were 10% to 1% of the amount of money involved here.
Right. I mean, just personal experience, I think we've all had this with, if we have compliance, and I do, the mistakes when somebody, a friend is their treasurer or something, tries to do this, it's not of this scale, even remotely. My experience, you're not aware of. The amounts that, this is to committee staff, the amounts that Trinity Health Services received from the Florida Department of Emergency Management, these were federal funds, taxpayer funds, granted to the state of Florida to support COVID vaccination registration programs, correct?
That's correct.
And as noted in paragraph 106 of the SAV, page 17, at least 3.6 million of the funds paid to Trinity under the FDEM contract made their way into the respondent's campaign for at least some period of time, correct?
Yes, that's a generously conservative number.
Could you extrapolate?
Well, as seen on the flow chart that we were looking at earlier, we had about $8 million going from Trinity into the accounts of the respondent and her family members. And the vast majority of that, approximately $6.5 million, if not more, made its way into the campaign.
So
some of it did make its way back out through repayments to the Congresswoman, which some of which was then put back into the campaign, which is why we went with the conservative number.
So as far as admission goes, there was a settlement with the FEC, going back to that?
Yeah, so the FEC did issue a reason to believe finding at some point during the campaign relating to some problems on the face of the campaign documents. And there was a settlement recognizing that the kind of typical campaign finance issues that you guys know better than we do, where the cash on hand wasn't adding up, or there were excessive contributions that needed to be reattributed and refunded. And there was a settlement entered into because it was a pretty widespread issues, but the findings of the ISC go far beyond what the FEC looked at. The FEC wasn't looking at her bank records, which bear little resemblance to her FEC reports.
In terms of the movement, all of these movements from account to the campaign, clearly they were preceded by a movement that was taxpayer funding.
Yes, very quickly proceeded. There would be a large transfer of funds from Trinity to the respondent, and then immediately from respondent to the campaign, if not through one of her siblings or their corporations.
I know this isn't completely in front of us, but just as a cash flow thing, as a former small business person. So that money went to services and profit sharing, but then there was a settlement with the Florida Department to repay that. So I think the average person would go, well, if all of this is factual, where is the money now? And there was a settlement to repay. Is that an accurate description? And I'll let you respond to this as well, Mr.
Yeah,
President.
so there was a little more than $14 million paid by the state of Florida to Trinity Healthcare. Some of that was paid to by Trinity to nurses, a few $100 paychecks to administer some vaccines, but more than half of it was paid to the Congresswoman and her friends and family. And of that, the vast majority went into her campaign. Subsequent to that $14.5 million being paid out, it was discovered that at least $5 million of that was an overpayment on an invoice for $50,000 where the decimal point was moved. And I understand has been a settlement between Trinity and the Florida Division of Emergency Management, but that the Congresswoman is not a party to that settlement. I'm not aware of any process in place for her to pay back the money that she received from Trinity to.
That's enough. I'll give you, if the chairman will indulge me, Counsel, you want to respond to my line of questioning?
Yes. I think let's just sort of back up a little bit and begin with the understanding that the state of Florida was sending Trinity Healthcare funds. And I think that over the time period that we're discussing, they sent approximately $14 million. At some point, the state of Florida said that they had made a mistake and had overpaid $5 million. Let's be clear, there's no suggestion that the Congresswoman did anything inappropriate in order to try to steal the state of Florida's money. They sent it to her, to Trinity rather. And then Trinity did what businesses do when they get a large influx of money, and that's they often pay it out in profit to their owners. And she had a profit-sharing agreement where she receives a certain percentage of the profit. After the monies were all paid out, Trinity entered into an agreement with the state of Florida to pay back the overpayment of the $5 million. Trinity is on the hook for that money because Trinity is the entity that received the money and Trinity is the legal entity that dispersed it. The Congresswoman is not on the hook for that money, Trinity is. Now, Trinity may decide to go to the Congresswoman and try to seek reimbursement for whatever money she received under the profit-sharing agreement, but legally speaking, the overages that were paid to Trinity, that's a contract between Trinity and the state of Florida. Now, this flow of quote unquote Trinity funds on this flow sheet from page 6 doesn't indicate how the money ends up in the campaign, because it's suggesting that the money is flowing directly through Trinity through some kind of false shell corporation. And that is just simply factually incorrect. The monies that were paid from Trinity were paid, much of it was paid to her consulting corporation, for example. And the consulting corporation took on a much broader scope of work than Trinity had under the contract, under her agreement with Trinity. So it was work that's not covered by her salary. It was outside work. And this, you got to remember, this is happening during COVID. And the Congresswoman is driving around the state of Florida trying to get unrepresented communities vaccinated from the COVID virus. That's what she's doing. And that work is what the consulting work was doing. And that was what Trinity was paying. I understand, Mr. Chairman, that this committee has a right to decide issues on summary judgment. And I also understand the frustration the committee has with the way the case has evolved. And I acknowledge that. My argument isn't that the committee is doing...
Counsel, with all due respect, you've already answered those questions.
Okay.
I wanted you to have time to respond to my questions, and we've gone over.
Thank you.
Just follow up with counsel. Do we have a valid profit sharing agreement?
I don't know which document counsel is referring to, if it's something that has not yet been provided to the committee. I do know, I am not familiar with any document that appears to even resemble a profit sharing agreement with Trinity Healthcare Services. I do know that in January 2024, your colleagues on the investigative subcommittee, the very first question they asked the Congresswoman was, please provide any profit sharing agreements that you have with Trinity that show that your legal right to these funds, and that we repeatedly followed up with her various counsel to try to obtain those documents. And I'm not aware of any such document.
Okay.
We filed it yesterday.
Thank
with
you,
the
Mr.
committee.
Chairman, I yield back.
Gentleman yields back. And just for the record, I'm not going to hold members to the 5 minutes. Want to make sure that all members have the opportunity to have their questions answered. So would ask members to be respectful of time, but also want to make sure that we are not cutting members off as they seek to have their questions asked. So at this time, the chair recognizes Ms. Henson.
Thank you, Mr. Chairman. I would ask our committee counsel to kind of walk us through the dates of the establishments of these companies that are listed on the flow chart on page 6. Can you explain kind of the dates that those were established and how that money flowed through those, since the defendant's counsel just brought that up, please?
Yes, thank you, Congresswoman. So the agreement with Florida Division of Emergency Management was dated March 4th, 2021. On March 12th, 2021, respondent registered SEM Consulting Group LLC with the state of Florida. On March 11th, her brother registered EC Firm LLC with the state of Florida. And on March 11th as well, her sister registered MC Nursing Journey Consulting Firm LLC with the state of Florida.
And these are all their initials
Yes.
tied to these companies. And then those dollars then flowed, as it lays out on this, into the respondent's campaign through various means, correct?
Correct.
I'd ask a question specifically about count 26, the CPF-related count. Can you kind of connect the dots on the statement in that says respondent instructed her staff to be proactive only about a CPF request from individual 3 and was more invested personally in this request than other requests? Can you kind of lay out what you're inferring there and how that process unfolded for the CPF request?
Yes, so individual 3 is an individual who had a campaign relationship with the Congresswoman and was a personal friend of hers. And
Was this person a donor to the campaign?
yes,
or-
yes, in addition to a vendor for the campaign through his for-profit company. But he also had a foundation that had an earmark request for a telehealth tablet program. Unlike other programs that were seeking earmarks from the office, the legislative staffer overseeing that process was explicitly directed to reach out to this individual to make sure he was aware of the process, the appropriations process at issue. And according to that staffer, she was told that it was a priority for the Congresswoman to make sure that this individual understands the process and that they do submit a request. No other recipients of community project funding requests were the subject of such proactive outreach.
So as a result of that outreach, and then the project itself was not eligible, is what this document says?
No, there's 2 separate charges with respect to the community project funding request. So that individual did indeed receive a appropriation, and it was eligible, and it received $2 million. Another individual who also received special favors in that he provided a list of other companies, not entities he was directly affiliated with, but projects that he wanted the Congresswoman to support for community project funding. His requests were prioritized, and when the staffer running this process noted that, one of these isn't even eligible, it's not even in the district, the Congresswoman kept it on the list despite that, and told that staffer to apologize to the friend who had provided the list of projects that he wanted.
So it took up a slot of the 15, knowing it would not be eligible, correct?
Yes.
Yes. Mr. Barzee, I know you just said that you submitted the evidence of that profit sharing agreement yesterday. What date was that profit sharing agreement entered into?
Do we know what date it was entered? That's the date that it was sent.
Yeah, and
I mean,
I'm referring to the document that you were just discussing.
Yeah, what I have on it, on as far as the date stamp is concerned, is it goes back to March 29th, 2021, but I believe that's the date that it was sent from one person to another. As far as the date that it was entered into, the agreement was entered into, right. Of what year?
Mr. Chairman, I don't believe we have that document he keeps referring to.
All right, so
Is this the document you're referring to, this chart with the hours of service and?
it's a document, the document I'm referring to right now is titled a projected financial report, and it was filed along with the summary judgment response. And it indicates that there was a profit sharing agreement in place as far back as February of 2021. But I don't have the date that it was actually entered into. I can get the committee that date, and I can call a witness to testify about the profit sharing agreement and how it included work that the Congresswoman was doing separate from what she was contracted to do for Trinity.
Does committee counsel have any response to that? You reviewed this document.
I'm not familiar with this document. I don't believe we have seen it. We're not aware of a document that meets that description. The inability to identify the date of it makes me question to what extent it is an agreement. It sounds like there aren't necessarily dated signatures on it. To the extent what's being referred to is the projections document with 110% of the profits divvied up between the respondent and her siblings. I don't understand why that would be considered an agreement with Trinity, but regardless, it's immaterial to the question of whether the funds that respondent and her siblings received from Trinity were those that they had legal title to, or whether she intended to funnel that money into her campaign.
Okay. Thank you. That's all my questions, Mr. Chairman.
Gentlelady yields back. The chair recognizes Mr. Ivy for his questioning.
Thank you, Mr. Chairman. The document where you were just talking about, is it this spreadsheet thing or something different? Because it doesn't, the projections document that counsel for staff mentioned doesn't have the heading that you referenced.
It must be a different document, sir.
Okay.
The
Well,
document in front of me is titled Projected Financial Report, and it has the corporate administrators, the different sites, and it has under the column for bonus amount, it shows what the profit sharing agreements were. And I
okay.
could bring a
I don't want a
witness to the
witness. I want your representation.
All right,
just
well,
to
my
witness.
representation is that she was entitled to a certain percentage of profits, and Trinity paid those profits out when it received monies in, and that there was nothing nefarious or improper about that. But if you look at the staff's complaint, I mean, everything related to count one, basically, from paragraph 306, 307, 308, is all suggesting that whatever came from Trinity is tainted, and it came directly from Trinity.
Well,
And neither one of those are factually accurate.
let me give you a chance to refute those point by point. But with respect to the flow of Trinity funds flow chart, 2021 to 2022, page 6.
Okay, yeah.
Okay. So, and I guess this is aimed at capturing what you were just talking about. Staff counsel, which counts is this supposed to illustrate?
This relates to several of the accounts, to the extent that the issue is the funds that went through respondent or SCM Consulting. The notion that they're not her personal funds because she did not have legal title goes more towards count 2, and only a small portion of count 1, because as indicated by the flow of funds directly from Trinity, from EC firm, which she only had 50% title to, from her brother and from her sister, those were excessive contributions that could not be made, that were funneled through those individuals into the campaign. Council is mistaken.
Okay.
It's
Does
not
it
all
cover
through.
other counts other than
Okay.
count 1 and 2?
Yes, it
What
also
else does it
covers count 5, 6, and 7.
And those are
5,
what?
6, and 7. So count 5 charges her with acceptance of improper campaign contributions from her brother, Edwin Cherfilus. Count 6 charges her with acceptance of improper contributions from her sister, Marjorie Cherfilus. And count 7 charges her with acceptance of improper campaign contributions from Nadege LeBlanc. They
All
don't
right,
make
let
up
me-
the entirety, but
Let me
yes.
go to counsel for the Congresswoman. What do you dispute on those points?
How is that an illegal contribution? If her brother is paid by Trinity and does work for Trinity and the money is his because Trinity pays him for it, why can't he contribute to his sister's campaign?
Well, a couple points on that, I suppose. The amounts and staff counsel, I guess these are pink, the amounts of money that flowed into the respondent's campaign from SCM Consulting, respondent EC Firm, respondent's brother, respondent's sister, and MC Nursing are $3.4 million, $350,000, $2.2 million, $390,000, $5,800, I guess is the one you're talking about, $2,800 and $5,800. So with respect to the larger amounts that would be over what an individual contribution could be, is there, and that would be let's take the 3.4 million or the 350,000. What is your position with respect to why those are appropriate contributions? Or are you disputing whether this is factually
No.
happening?
The Congresswoman is legally permitted to contribute to her own campaign, correct? She can use her own money.
Right, and did she do that in the form of a loan or a contribution?
Well, I'm not entirely certain. That's one of the things that we could figure out if I could bring a witness in here to testify as to who was filling out the financial affidavits and those forms. I don't know that they did it correctly, but the intention of the Congresswoman was to loan the campaign monies, and then at some point, the campaign apparently returned those loans back to the Congresswoman.
Okay,
But
so,
if it's her money, she can loan her own campaign the money.
okay, so the respondent flow is 2.2 million, right? Or are you disputing that?
From altogether, you're saying?
No, so you see the pink boxes?
Oh, yes, I see it. I see it.
Okay.
Yes, sir. Got it.
So that would be the amount that she contributed or loaned to her campaign?
Correct.
All right, now with respect to the 3.4 million, if you go over and that goes to the box, joint account, respondent and brother. What's your position on that one? From a factual standpoint?
That's her money. I believe that they owned that account sort of joint and severably, that they both had access to it. But I believe that that's her money as well. Yeah, it's her, thank you. Factually speaking, it's actually her account. He was a signature on it, but all of the money in the account was hers.
So
And
you-
I would bring him in to testify
No,
to that.
So the fact that it's a joint account, in your view, makes it permissible under the campaign finance?
The money belongs to her.
Well, if
He
it's a-
was a
if-
signature on it.
Is it a joint account or not?
I'm not sure what the bank itself called it.
Okay.
I'm not trying to be clever.
No,
I
no,
honestly
okay,
don't know
fine.
what the bank
That's fine,
called
that's
it.
fine. What about SCM Consulting and the 350,000?
That's her company. That's her consulting company, which I don't believe the consulting company put that money into the campaign directly. I believe the consulting company gave it's a sole proprietorship, so it was able to do that. Yes.
All right.
And that's
Well, let me-
hers.
Let me pause there for a moment and go to staff. So just to go through those three, the 3.4 million that came, you've got here listed, it's a joint account, respondent and brother. Is it a joint account under your understanding?
Yes, that's my understanding based on the bank records.
All right, and would it be permissible for the joint account to make that contribution to the campaign?
It would depend, no, because of the way that the campaign finance rules operate, it would only be about half of the amount in the account could be donated onto her. But I do want to make clear, the subcommittee did not charge that as an improper contribution from her brother. It focused on the more clear examples.
Okay. Then what about the 350,000 from SCM Consulting?
SEM Consulting is a single member LLC. It's treated as if it's a loan from the candidate. That is
So
permissible if she
That's
has legal
permissible.
title.
All right, what about the 2.2 million from her? That's permissible, right?
Permissible if she has legal title.
All right, so then we get to the EC firm, 390,000.
Yes, 380,000 of that would have had to been considered half a donation from her brother who had 50% ownership of it, making it an excessive contribution. 10,000 of it was
And
actually,
just before you move on, it's an excessive contribution because the maximum contribution would be what amount?
was $2,900 election.
$900. Council, with respect to the EC firm contribution of 390,000, you just heard from council that the max is 2,900. What's the material fact and dispute on that position?
My understanding is money did not flow directly from EC firm into the campaign. So I'm not sure that, I mean, I may have an objection to this fact here, or at least to the flow sheet.
Okay,
But my understanding factually is that money did not flow the way it is indicated here directly from EC firm into the respondent's campaign.
counsel for the committee, do you
Uh,
have records that show that the money went directly from EC firm to respondent's campaign?
Indeed, we have both sides of the transaction. We have EC firm's bank records and the campaign's bank records, both of which show the direct transfer of funds.
So the 390,000 amount, you've got bank records that show that that came out of the EC firm and that it went,
Oh, got it.
it went directly to?
Yes,
the-
over the course
the
of
campaign.
multiple payments. Not one giant 390, but
Okay.
over a few.
Okay, I'm sorry, counsel for Congresswoman?
And that was the Congresswoman's money. She had a 50% interest in EC firm. And there was a separation agreement. It's not just hers, I mean, her brother's, it's hers as well.
Committee counsel, is there such an agreement in
So
place?
as a matter of law, the portion donated while she had 50% ownership is, she only had legal title to 50% of that under campaign finance laws, but an additional $10,000 was actually donated after she entered into the separation agreement and had no ownership over EC firm, thus being in itself an excessive contribution.
All right, well, let's stick with what you got here on the exhibit. So the
Uh,
300,
I'm sorry, those were repayments, just to clarify.
Okay,
The
so the
money
three-
going back.
so the $390,000, you're saying that that's more than half of what was in the account out of the EC firm? She had a 50% ownership of the amount of money that was in the account because she had 50% ownership of the EC firm?
Correct.
Is that right? All right. So was the 390,000 more than 50% of what was in the EC firm account at the time?
Yes,
Yes. How much more?
I don't have that in front of me.
Okay. Counsel, do you,
Sorry.
EC firm apparently received at least 600,000 from Trinity over the length of the firm's existence. It had much more than that, correct? It had
Yeah,
more
well,
than that.
it's got the 600 over the EC firm box. And Chairman, you cut me off when I've gone too long, but I'm just trying to walk through the exhibit to make sure I understand. So if I'm understanding how the document's designed, the 600,000 shows that that amount was put into the EC firm from Trinity Healthcare Services.
That's correct.
Trinity, you can talk about the funding request.
Please don't, please don't, please don't, please don't. Talk to your counsel and let him make the representation.
That was good of you to do that.
Counsel, put your hand over the microphone. Okay.
As I said earlier, the Congresswoman was entitled to 50% of the EC firm, and they were paying out over time in installments, those payments.
Can I go the rest of the way across the chart? Okay. Just to make sure I understand what this is. Let's go to respondent's brother, that box. That's 200,000 come in 5,800 goes out. I guess the position would be that that is the 2,900 and 2,900, that that's permissible under the campaign finance law. So counsel for the committee, what's the position?
That is not the basis for the ISC's charge, the $5,800. The
It's not.
basis is the arrow going up for many in-kind contributions made through various shell companies.
All right. Well, so far now, the only box that's relevant to the charges is the 390,000. Is that right?
To which charges? I mean,
To the
these
SAV
boxes?
charges.
Well, no, to the extent that some of the charges relate to her, the loans that did come from her personally, there are charges relating to the fact that they are not considered to be one she has personal title to. Although I don't think any charge relies wholly on it.
Okay.
Yeah.
Let me go to respondent's sister. That's 2,800 that comes out,
You get 2,800 directly, yes.
that goes direct, and that's a permissible campaign contribution?
Yep.
All right. And then Nadaj LeBlanc and her LLC. Is that 5,800?
Yes.
All right. Are you saying that's permissible or impermissible?
We're saying that was a conduit contribution as part of a straw donor scheme whereby the sister provided the funds to Nadej LeBlanc to contribute to the campaign.
And that is based on what, a bank record that you got?
Bank records and text messages. There's a text message where the congresswoman explains that the max is 2 checks of 2,900, and that is why her sister gave Nadej the money.
Is that one of the exhibits in the motion that you filed?
It is. It's also on the PowerPoint.
Okay. All right. I'm going to end on this page. I'll come back later. But so on this page, if I'm seeing this correctly, the 5,800 from Nadaj is counsel's alleging that that is which count that's violated there?
Count 7 and count 7.
And I'm going to come to the other one too, so you can look that one up. That's the 390,000, I guess. Which count does that go to?
The 390, which one is that part of?
That is from
Apologies.
EC Firm. That's the one where you're saying that it was more than half of the amount that the firm had. Which count does that go to?
That goes towards count 5, but it's not the only basis for that count.
Count 5. Okay. So, and the last question. So for the other blocks of money going to respondents' campaign, those are not alleging, correct me if I'm wrong, you're not saying that those stand for allegations of particular counts in the SAV?
I think all of them relate to some count in the SAV. I think that
Well, you got to tell me.
the funds flowing from SCM Consulting and Respondent relate to the allegations that the contributions she reported as personal loans were not actually personal loans, but were conduit funds from Trinity Healthcare Services.
Right, now, before you move off of that, because I didn't know that was there. So what's the basis of that allegation?
In part, her use of funds that she did not demonstrate legal title to, but also these other funds that were moving through other individuals from Trinity, from that initial $8 million that gets spread across into the campaign.
I'm not sure I follow what you're saying there. So you got the 350,000 from SCM Consulting, right?
Sorry, 350,000.
That's here on the
yes,
kind of to the
yes.
left.
So the argument is that that is one of the facts that contributes to the count that there were conduit funds from Trinity Healthcare Services and that she improperly reported those as personal loans. And
Right, but you were saying earlier, I thought though, that since it's that she owned the consulting firm, that was permissible for her to loan or contribute that amount?
yeah,
under
if
FEC
there
rules?
was $4.4 million in her consulting firm that she had legal title to, she could donate that to her campaign. But the argument is that she did not have legal title to it because there is no real profit shared agreement that meets the legal requirements under campaign finance laws for what is considered personal funds.
Okay, so the 350,000, and I promise I'll stop after this. The 350,000 that came out from SCM Consulting to respondents' campaign, was that money actually in the SCM account?
Yes.
All right. So, counsel, your position on the 350,000 then, with respect to a material dispute issue, what's your?
It's the material, the key dispute here is whether or not whether or not she had title to this money, whether or not the Congresswoman had earned this money appropriately, and that she had reason to believe that that money was flowing to her appropriately from Trinity. This was a family business. Her brother, her sister, they're all involved in the business. The state of Florida makes a mistake and sends them too much money. They were receiving 14 million.
I'm going to ask you to keep it right to SCM Consulting if you can. We got the 14
okay,
million.
well, all of the money,
Okay.
every single penny from SCM Consulting is owned by the Congresswoman and is appropriately there. It's not tainted money. That's the problem that I'm having with the committee's argument, is it seems to presuppose that all of this money is somehow tainted, and it's not. There's been no evidence that any of this money is tainted. This money was all appropriately transferred to SCM Consulting. It was all appropriately transferred to her brother and sister. There's nothing wrong with any of that.
Let me yield back. I thank the chair for your indulgence, and I'll come back. I do want to, if we get another round, I'd like to ask about the 2022 reelection funds, kind of same line of questioning.
Is there one thing that I can add, please?
Yes, sir. If the chair is agreeable.
Okay. Yeah, not only is this a question of them receiving appropriate profit sharing from Trinity, but that money was earned. That work was done. The Congresswoman was driving around the state getting these communities vaccinated. It wasn't as though she's just sitting back receiving money flowing in. She's out there working.
Okay.
And it was completely appropriate, and it was earned, every penny of it.
Okay. Thank you. Thank you, Mr. Chair.
Thank you. Gentleman yields back. Before defer to Mr. Moran, I'd like to ask if the staff director, again, to clear up the record, would hand to the Respondents' Council an exhibit that was attached to your motion in opposition to summary judgment, which I believe is what we have referred to in some of the arguments as a profit-sharing agreement. And I want to make sure that when we talk about the profit-sharing agreement, that that's the document that you're referring to, or if there is another document that you're referring to, please make sure that we can make sure we're viewing the same document.
I don't think we are. Thank you. I'm glad you caught that.
So,
Mr. Chairman, he appears to be talking about a different document.
Yes.
That frankly,
do you have a copy of that document, Mr. Barzee? The document that you are referring to as a profit share?
Yes,
the
sir.
document that we handed you was a document that was attached to the motion for summary judgment. Do you have a document that's referred to as a profit sharing document?
Yes, sir. And I'm passing it to staff counsel now.
And are you agreeable to us distributing to members of this committee?
Yes, sir.
Yes. All right. Thank you very much. I just wanted to clear.
Mr. Chairman, if you'll indulge, so could he identify what this is?
The document that was handed to you, which
There's
is
no
at the
title,
top
no
labeled
date.
projections. Mr. Barzee, can you please identify the document that the staff director handed to you and which is attached as an exhibit?
I believe that document was, I'm sorry.
See the week? Since the same document looks like it's much smaller.
Congresswoman, I'm not entirely sure right now. It's not the document that I was familiar with.
Well, I realize that, sir, but this one has no title, doesn't tell us
Yeah.
what it represents.
I
There's
don't-
no date. We don't know who prepared it.
I agree with you, and I'm not sure, and I can't even read it. I'm going to need a magnifying glass to get
Well,
to it.
we blew it up.
Oh, the new one.
Yeah, I think they handed you that, didn't they?
I handed him the original document, but if you want to hand him the blown up copy, so that he
That was
can.
attached to your motion for summary judgment.
I understand.
We couldn't read it, so some staff blew it up for us.
Understood. Thank you. It says the same thing as the same document that we provided just now to staff, which is that there is a percentage of profits on the document that was attached as part of the motion. And that's what I'm referring to as the profit sharing agreement.
Well, I'll ask more questions about that when it's on
Yes, ma'am.
my turn. No, go
Understood.
back to the
Thank you.
judge.
And I think they're making copies of the document that you provided. Once that document is returned, we will distribute it to members of the adjudicatory subcommittee and also make sure that committee counsel receives a copy of that document as well. So Mr. Moran, you are recognized for your questioning.
Thank you, Mr. Chairman. I'm going to start where you just left off because I had this as my number one question. You had referred to a profit sharing agreement early on. Now we know what you're really talking about is a chart. Is that correct?
Correct. Well, they were both.
Right. It's an unsigned chart.
Correct.
All right. I will have to say I did a lot of business transaction law for a number of years before I came to Congress. I drafted a whole lot of profit sharing agreements. Never saw one that was just a chart that was unsigned. All that you've been able to produce at this point is that unsigned chart that you contend is a profit sharing agreement. And you've made a lot of argument about the fact that your client was entitled to the funds that were flowing through Trinity Healthcare Services, at least adding up to $6.7 million to her directly and to SCM Consulting, which she owned wholly. Am I correct about that?
I'm not sure of the $6 million figure that you're referring to.
All right. Well, that's what the evidence shows that that council has produced. That's what's on the chart. That's what we've been referring to the whole time.
Right.
But nevertheless, whatever the number is, you've said, and we know it's in the millions, you've said she was legally entitled to that money and that she could loan that to her campaign if she wanted to.
Correct.
So the legal entitlement is, you've made a really big deal of today, but you've based that on a chart that's unsigned that you say is a profit sharing agreement, correct?
Correct.
All right. So that's very interesting to me, and I think should be instructive because considering that we've been undertaking this investigation for more than 2 years, I would think that if it was my client, day one, I would say, you know, a whole lot of the magnitude of the allegations here is wrapped up in whether or not you had entitlement to at least $6.7 million worth of money flowing from Trinity Healthcare Services that you say, quote, are appropriate profit sharing, and which you also argue is she's entitled to for driving around the state talking to people about vaccines. I wished I'd had a job like that.
It was more than that, sir. Much more than that. And frankly, that's offensive to suggest that all she was doing was driving around talking to people.
No, actually, that was exactly what you suggested. And you
was
also
a lot more than
suggested that I think it's frankly offensive that you would suggest that an unsigned chart actually qualifies as a profit sharing agreement. Now, let me move on and talk to you more about that, because if in fact your client was entitled to that under a profit sharing agreement, I would think day one, I would say, hey, give me the signed profit sharing agreement. Let me turn it over. And your client in 2 years has not done that, even though she was asked by counsel to do that at the very beginning. Now, I'm going to come to counsel here in a second and ask us.
May I respond to that?
Sure, go right
Please.
ahead.
Congressman, this is a family business. Not every family business in the United States hires lawyers and puts everything in writing and creates corporate documents. Sometimes family businesses are decided around the kitchen table, and there's an agreement and there's an understanding.
If you're
I'm
getting,
not
if you're getting
saying that this is
if
a
you're
profit
getting near
sharing.
$7 million, actually you're getting $14 million from the state of Florida, and you're then taking at least 6.7 million of that for yourself, I would think that you would want to document that. I want to come to council for a second and ask you about the statement you made at the very beginning, because you talked about opportunity for the respondent to clarify, to provide a list of witnesses and exhibits that might exonerate her or provide facts that would contest the facts that you were looking at. Talk a little bit about the timeline and the opportunities that respondent has had over the past couple of years to provide a list of witnesses and exhibits that she could then rely on to provide some kind of contest to the facts today.
So Congresswoman's opportunities have been myriad. Most recently, in connection with this hearing, there was a pre-hearing schedule set by a certain deadline. She could provide a list of witnesses that she wanted to call here today. She did not submit a list of witnesses. She could have provided any information. She could have sought subpoenas, and she did not do that by the deadline set in the pre-hearing schedule. But that's just this most recent adjudicatory phase. She has also been provided with every opportunity throughout the 2-year investigation, because the investigation is not a prosecution. It's an effort by her colleagues to understand what happened. And I think something that has not come up yet but is notable is this investigation came from a referral from the Office of Congressional Conduct. And when the Office of Congressional Conduct makes a referral, they write a report with their findings, and we give a copy to the respondent. And we say, please respond to this. Tell us if they got anything wrong, anything you want to add. Counsel has made some reference to her prior counsels denying the allegation, but that's not an accurate representation of the responses that her prior counsel submitted on her behalf. It really sidestepped a lot of the allegations that were put forth by the Office of Congressional Conduct. And then subsequently, when we followed up through requests for information in the normal process, seeking information about what was in that referral and other allegations that came to light, her responses were limited. We did not get profit sharing agreements. We did not get direct responses. And at all times, she was free and often encouraged through her counsel to provide an explanation for what was going on here. We never got one.
Thank you, counsel, for that clarification, because I think that's what's most telling to me is if we were really dealing with a contest of fact, those facts would have been presented in documentary form by the respondent at some point over the past 2 years, or at least provided by her counsel over the past 2 years, and they have not been. I want to also reemphasize something that you mentioned earlier. I want to be sure that this is clear for the record. If a member delegates authority for filing her disclosures, managing finances, can she delegate legal responsibility for compliance?
So the answer is a little more complicated depending on whether you're asking for legal responsibility from the perspective of the House and legal responsibility from the perspective of the Federal Election Commission. The Federal Election Commission does have the treasurer as the person with liability for the campaign's conduct, and the extent to which the candidate can be held responsible for that is maybe a little more complicated and also immaterial, because as a member of Congress, her obligations are greater. And the committee's longstanding position is that she is on the hook from an ethics perspective for the conduct of her campaign.
And I think I heard you say earlier, or Sydney, when she was giving her presentation, that was it 60 or 16 times she filed a financial disclosure that was incorrect?
60, maybe 61 since her most recent filing may have occurred since then.
60 times. All right, thank you. I yield back.
Gentleman yields back. Before I refer to Ms. Garcia, want to make sure, again, just getting back to the document, there has been a document distributed. I have a copy here. And again, just want to make sure this is the document that we've been referring to as a profit sharing agreement. The heading of that document says projected financial report XLSX, and at the very top it says Gmail. Is that the document that you're referring to?
Yes, but I don't mean to say that that is a formal legal profit sharing agreement. What I'm trying to say is that that is evidence of a profit sharing agreement that existed with the family members around Trinity Healthcare, just to clarify.
Yes, sir. And committee counsel has been provided a copy of this document. Is that correct?
Yes, we have now.
All right. I would like, just for the record, to be clear that we will introduce a copy of this into the record. I've written on mine, so I'd like to introduce a clean copy We have one here, so we will make sure to make this an exhibit to the record. So if there are any questions, the record is clear as to the document that we have been referring to. Do you have any objection?
None whatsoever.
Any objection from committee counsel?
No.
The document will be entered without objection.
Mr. Chairman, I would like to respond to Mr. Moran's questions that were directed at staff that I didn't have an opportunity to respond to,
Go
if I
ahead.
may. And well, it's about all the time she was invited to come in and cooperate and give them documents, and we're making the point that staff is making the point that this isn't an adversarial situation. And of course, a member should just turn over all the documents immediately if it's requested. But you need to understand from the point of view of her prior counsels. And her prior counsels are receiving requests for documents and receiving requests for interviews at the same time that they're aware of the Department of Justice doing a criminal investigation. And so her prior counsels did what prior counsels will do in that type of a situation, and they will advise the person that they have to be careful, that they have a Fifth Amendment right to protect. And so I don't want it to sound like she was ignoring this committee, because that's not what was happening. There was no disrespect meant to this committee. What she was doing was following the advice of following the advice of counsel that was based on those attorneys' beliefs that whatever materials she was turning over, whatever she was going to say to the committee, could turn around and be used against her. There is no secret here that the Department of Justice has a very close relationship, working relationship, with committee staff. For example, when the Department of Justice decided that they didn't want committee staff interviewing witnesses because it might interfere with their strategies, they didn't put that in writing. They didn't send that to the committee. Someone from the DOJ picked up the phone and called someone on committee staff. So you can understand why her prior attorneys would be a little reticent to turning over files and documents, knowing that they're all going directly to the DOJ, who is in the process of investigating her. Why would her prior counsels allow her to just give up her Fifth Amendment right automatically? There's no disrespect to the committee, sir. She's cooperated. She's had attorneys. I understand it hasn't gone quickly. I get that. But with all due respect, this is what she was advised to do.
When Mr. Moran wants to follow up with that, I would like to add that documents that we obtain as part of our ethics investigation, those documents are not shared with the Department of Justice. That has been standard procedure of this committee, and we have actually fought the Department of Justice when they have come in and tried to obtain documents that we obtain as part of an investigation into an individual member. So I understand that that might have been what her attorney believed would have been the free flow of information. But for the record, we have repeatedly denied requests from the Department of Justice, and we have fought subpoenas from the Department of Justice when they have attempted to obtain information from this committee previously.
I appreciate that, but I hope the committee appreciates the concern her prior attorney would have, knowing that the relationship between the DOJ and staff is so close that all they have to do is pick up the phone and say, stop interviewing witnesses, and the committee staff immediately would agree.
Well,
Now, I understand that's not exactly what happened in this case, because they had already done the interviews, but the point is, you can see why her prior counsels were concerned about turning over documents. It's an understandable concern, especially when you have a client who's facing a federal indictment.
Ms. Moran, did you have any follow-up question to that?
Just follow-up comment. Your argument might carry more weight if this was an incriminating document. but it is, in your words, an exonerating document. In fact, a central exonerating document. It is the kind of document that you would reach for first in about 2 minutes, and you would produce intentionally to protect your client. So you've made an argument to the extent that prior counsel might believe it was incriminating, but you have told this committee it is an exonerating document. So your argument does not hold weight with me.
Oh, I believe it is an exonerating document, and I appreciate the member for recognizing it as such. It does exonerate her. Prior counsel was concerned about a violation of her Fifth Amendment rights, and that's why they don't turn anything over, because they're afraid and they're scared. And I understand that, and I'm asking the committee to understand it, because that's what happens in the real world. When you have a client, and this is why we were asking for a stay, when you have a client who is facing criminal prosecution and criminal consequences, you don't turn over documents. You invoke their Fifth Amendment right, and you wait for a trial.
But you do turn over in a document if it's exonerating, and we haven't even seen a document. You can't even show us a document at your table, even if you don't want to give us to us today.
I have
All you
given
can show
it
us
to
is
you.
a chart.
No, well, that's the document. The document is a chart, and it's a chart that shows.
Unsigned, undated chart.
Sir, this is a family business who make agreements around a kitchen table, and there's an agreement that mom's going to get 10% and brother's going to get 20%, and you're suggesting somehow that that's nefarious. That's how family businesses work. They don't always run downtown to get a lawyer to put everything and memorialize everything. I showed you this document in order to support the idea that there was a profit-sharing agreement.
Gentleman yield. Gentleman yields. The chair now recognizes Ms. Garcia.
Thank you, and not to belabor the point, but I was wanting to clarify the document that you did give us, because I too am concerned that it's undated, unsigned, and we have no idea when this chart was prepared. So do you happen to know, counsel, when the family got together and formed this agreement?
I do not. I understand that that's an important question. I can tell you that that agreement was in existence as early as February of 2021.
February of 2021.
Yes.
Because in February of 2021, the Congresswoman signed a letter, February 24th of 2021, under a letterhead of Essential Community Health. Was that the family business at that time, or who is Essential Community Health versus Trinity Healthcare Services?
That's a different corporation. That's a nonprofit corporation that you're referring to, I believe.
Well, I don't know. I'm asking you, sir. This purports to be the beginning of the request for participation in the state's COVID-19 vaccination registration as soon as possible. And then she outlines the project overview.
They said that we needed a licensing, the same licensing at Trinity. So they requested to switch to Trinity because of the licensing library.
So, Congresswoman, can you please point me into what you're asking again?
I just want to kind of chronologically, you're telling us that this unsigned, undated, we
Right.
don't know who prepared it, when it was printed, is evidence of a profit sharing agreement.
Correct.
For her consulting firm, right?
Trinity.
Okay, because the document I have is dated February 24th, 2021 from Essential Community Health. It says Sheila Cherfilus-McCormick, JD, co-founder. That's the letterhead. She signed it as co-founder, and it's suggesting that Essential Community Health is ready to participate in the state's COVID-19.
Oh, I understand now. Yeah, no, originally, the ECH or whatever it was applying for these contracts to do this work for the state. They weren't able to do it because they didn't have all of the correct licenses, but they entered into an agreement that they were going to do it. When they discovered that there was a licensing issue, the contract got transferred over to Trinity, is my understanding.
All right, and then Trinity, she signs it as CEO Trinity Healthcare Services,
Correct.
LLC.
Correct.
So is she the CEO of Trinity Healthcare, or is she the consulting group?
She was the CEO of Trinity Healthcare Services.
But she also had the consulting group?
She also had a consulting group for tasks that were outside of what her designated job duties were at Trinity.
Okay, because your projected financial report lists her as executive director, not as CEO and not as co-founder.
She's the executive director of SEM Consulting.
Okay, because it doesn't refer to, because it says number of corporate administrators. I thought she was an LLC and not a corporation.
No, I mean, Trinity's a corporation. Yeah, Trinity's an LLC. I mean, I see what you're saying is that the words here says corporate administrator. I don't think that indicates their
Well, I'm just
official.
trying to figure out what her role is, because you say this purports to indicate that she worked 84 hours a week at a pay of
Correct.
70. I'm assuming that's $70.
Correct.
Independent contractor on site of a different.
And that began in 2021?
That's the-
As far back as, yes, 2021, correct.
Okay, because there's no year on this projected
I see that.
financial statement, sir. And
You
it
know,
doesn't tell us when it was- When was this printed?
I don't know, but it's attached to an email that we do have a date on of March 5th, 2021.
Do you have the
Yes,
email to introduce today?
yeah, I'll give that to staff and with the chairman's permission, it'll be distributed to the members.
Any objection from committee counsel? Have you seen the document?
No objection, have not seen it.
That's the email that was attached to.
Now, if I'm reading this correctly, it says 50% of profit.
Correct.
If it's I'm just trying to figure out how you figured out 50%. I'm trying to make sense of this financial report, and it's really hard to do that.
Each site had a different amount. Some sites come on another site. Each site had different ones. So we can record and with my dad. See?
Okay.
And this is how we were going to expedite it or execute.
I mean, the document in front of you is not intended to be a contract or a legal document. I'm offering it as evidence to show.
Well, I understand that, sir, but you've maintained throughout this hearing that she had a consulting firm,
Correct.
that she was entitled to all these dollars, and that it was
Correct.
solely hers. But this suggests that she was an executive director. There was a program operations director who was Edwin, a program manager, Nadej, an administrator, Marjorie, and Marie Smith, and they all have profits in there, and it totals 100%.
Yeah.
But I don't know that all those are the family members that sat around that table to make this agreement that you keep talking about.
Right.
Are all these people the relatives?
Yes.
Except for
Who is?
Except for, wait, I'm sorry, one of them is not. Who's not a relative? Nadej is not a relative.
that's my mother.
So we had an interloper at the family table?
She's like family.
All right, I'm just trying to make sense.
No,
of
no,
the
I get it. I
document,
get
sir.
it. This is not how business is generally, usually conducted in big corporations. Usually when you're dealing with multi-million dollar.
I don't want to get into that, sir. I just want to understand this document. So in the funding, federal funding world, I mean, I don't see a profit. It's usually work done by nonprofits that get federal funds. What do you, what was considered profit?
Trinity wasn't a nonprofit. Trinity was a corporation that made profit. And the family members had an agreement, family members plus Nadej had an agreement as to how they
Florida
were.
gave federal dollars to a for-profit company to do healthcare work?
Yes, well, the federal funds went to the state of Florida, actually, and then the state of Florida hired corporations to help them get people vaccinated.
Well, I'll ask.
I mean, the
again.
same way the state contracts
Right.
with a
don't-
hospital or a clinic.
I just want to know, how did you determine profit?
No.
Because you seem to suggest that if Florida gave you $5 million, whether it was an overpayment or not, that she was entitled to half of that,
Council,
which is really just the grant or the money you're being given.
No.
Council, I would push your mic away when you talk to your client.
Okay, thank you. No, these weren't grants. These were payments that were being made for services rendered.
Sir, if you would just answer the question, how is the profit determined?
Okay, give me a second. Profit was determined the same way every company determines profit. They get the money in, they pay the
All right, You're being
expenses.
disingenuous, Counselor. I'll just move on. When was S&M Consultant put together? When was it incorporated or?
We don't contest the dates that are in the documents provided by staff. I can go back and look at it for you.
Okay, staff, do you recall, please? When was S&M Consulting organized?
March 12th, 2021.
March 12th, 2021. And this work was being done in February and
Okay.
so you actually incorporated, you put the consulting firm together after this profit sharing agreement?
Yes, I believe that's accurate.
Okay. I'll pass for now. Thank you.
Gentlelady yields. Chair now recognizes Mr. Knott.
Thank you, Mr. Chairman. Mr. Barnes, I want to start back with where Mr. Moran left off. Your first assertion said that this was a profit-sharing agreement, correct?
This indicates what the profit-sharing agreement was. I'm not saying that this piece of paper is a profit-sharing agreement. I'm saying it's evidence of the existence of a profit-sharing agreement, and it's laid out in the paper.
Sure. But you would also agree with Ms. Moran that that is potentially exculpatory.
Yes, absolutely.
But you said you insinuated that it was somewhat simple because it was a family business, correct?
No, I'm saying the way family businesses work is they don't always run downtown and hire expensive lawyers to draw up complicated documents. Sometimes they just come to an agreement around the kitchen table. And that's what happened here. Her father was suffering from COVID. The family came together, they had a meeting, and they discussed how they were going to divide things up. They did it at her house.
Okay. You are aware that your client and her husband are attorneys, I believe. Are you aware of that?
I am.
Okay. It just seems remarkably simplistic given the
No, not if you're dealing with people that you trust.
But we differ on that. But
Well, I wouldn't make my sisters sign some kind of agreement with me. If I borrowed $50,000 from my sister, there wouldn't be a contract. We wouldn't agree to it in writing. We would just agree.
you're making a lot of references about the family business and corporate structures and so on and so forth. I'm just making the point. It seems remarkably simplistic given the structures that you've referenced, but we'll disagree. We will agree to disagree. I want to go back to the second point you made, that the reason why this was not turned over beforehand and the reason why there was not any compliance with the request for supplemental information from staff is because she was advised by counsel, your Fifth Amendment could be compromised. Do not turn this over.
Correct.
So this is the part that I had the biggest question about, because failing to comply, failing to file a financial disclosure actually makes you more prone to be investigated, would it not?
I believe it would, yes.
So counsel was saying, don't do something that will make your light shine brighter for the investigators, correct?
I want to understand that we're both talking about the same thing. You're saying that failure to turn over this document to staff?
Failure to fill out the required financial disclosures.
Right, that should have been done.
Should have been done, but was it your testimony or your argument that her previous counsel?
No. I'm saying counsel advised her not to turn over different things like this.
But it was her own decision not to comply with their inquiries into the financial disclosure.
No, whatever the committee's requests were made.
Yes.
The committee was making the request. She was represented by counsel at the time, and counsel was advising not to turn over documents to the ethics committee staff because they were concerned about her Fifth Amendment right.
Okay.
Period.
Okay. Now, staff, I'm going to give you a chance to respond, but just so that the members can understand who are watching this, or for counsel, in regards to the congressional financial disclosure reports that we're referencing here, this is not some zero tolerance gotcha game, is it?
Absolutely not. The committee recognizes that people inadvertently fail to file or make errors in their disclosure. Sometimes.
And matter of fact, it can be fairly common that members do forget to file, or they file a copy and pasted version from last year, or there could be ambiguities that need clarification, correct?
I think we had stats hovering around 30% of members have some error that needs fixing.
And that's year over year, correct?
Yes.
Okay. Now, in regards to what's been maintained, can I get the page number 6, the flow of Trinity funds from 21 to 22 on the screen? Taking a more bird's eye view here, I want you to respond, staff and counsel. The narrative, as I understand it from the respondent, is essentially that this was an established business. There were existing business operations. There was, on behalf of the state of Florida, there was a $5 million surcharge into these accounts. And then once that was noticed, there was an agreement to essentially repay. Other than that, the distributions, the profit sharing agreement that we've been hearing about, it was sort of business as usual, and there's really no way to know that this was being funneled into the campaign beyond the legal limits. And I just want to give you the chance to clarify why or why not that is the case.
I'm not sure I fully understand the question, but to the extent that at the time that these large loans were being made to her campaign, there was some press reporting saying, well, where did all this money come from? And recognizing that there was evidence of this COVID contract, and some questions were raised about that. But various aspects of the record got in the way of her competitive primary opponent's ability to recognize what was going on here, chief of which is that she failed to file a financial disclosure until after that primary, but also the fact that this money didn't all go directly to her campaign. Some of it was paid to the various PACs and other things that are at issue, as well as just the lack of transparency about what was going on with the profit sharing agreement.
Was there evidence that this money was was distributed with the purpose of ultimately ending up in the campaign.
There is evidence, and that is the investigative subcommittee's conclusion. The sheer timing of the payments, I think, is the most noteworthy evidence. The money would come in, it would go out to her, and then it would go into their campaign, or it would go out to someone else in her family. And in a few instances, it went directly from the healthcare company to the campaign. But beyond that, the council has suggested at some point that this profit sharing agreement sort of predates the scheme to get money into her campaign, but it's all part of the same campaign. And if you look at exhibits 2, 3, and 4 to the motion for summary judgment, that first exhibit 2 is an email from
Can we pull that up on the
January
screen?
2nd.
Is that, can we get a?
Unfortunately, I don't know. Can we put that on the screen?
All right.
It was an exhibit to the motion that you received, but it is an email from January 2nd, 2021 from the Congresswoman to her brother, Ed Nadej, stating, I will be running for Congress again and need to roll out my nonprofit, Essential Health. There has been some whispering going on that there may be a special election soon approaching. It even notes that the colors for the Essential Community Health letterhead should be the same as the campaign colors. And then Essential Community Health submits the proposal for the COVID funds that Congresswoman Garcia was talking about earlier. Later, that is converted into a request from Trinity. But it all flows from this initial plan to launch her campaign, set up this intended nonprofit that she never actually sets up, and then she starts receiving this money from the state of Florida that immediately goes into her campaign. And there is, legally speaking, no basis to conclude that she had a right to that money, because we don't see a consulting agreement. We don't see any basis on which to say that she had a right to that. She was previously earning $86,000 a year, and suddenly there is an overflow of money, and it all goes to her for reasons that are not articulated.
Other than on that page number 6 of the packet, did you have reason to believe that any of these entities were set up exclusively for funneling money to the campaign?
Yes, based on the times that they were set up and the lack of other action in their accounts or relating to those companies, all of these sibling LLCs, SCM Consulting, EC Firm LLC, and MC Nursing Journey LLC, do appear, and the evidence is clear and convincing that it was set up for the purpose of receiving these funds.
Again, why do you say that?
Because each was set up in the same week after she received the funds.
So again, that was my earlier question. I'm sorry it wasn't clear. This chart has a lot of different entities, and it was insinuated that all of these entities predated the money, were operating on autopilot, so to speak, and there was really no interruption other than the $5 million drop that was ultimately repaid. That's not the case. These are not all independent and functioning entities apart from the campaign. That's the conclusion that I'm trying to reach. And just for the sake of the record, this was not some sort of, we got $5 million, let's pay it back immediately to Florida, was it?
No, it was not. First of all, it has not been repaid. There is a settlement agreement that was entered into following litigation for Trinity to repay it over many years. But
there
that
was a lawsuit to reclaim the $5 million
Yes.
that they accidentally gave to the McCormicks.
That's correct.
No further questions, Your Honor, or excuse me, Mr. Chairman.
May I respond to some of that?
Yeah.
First, there's some confusion about the financial disclosures and what her prior lawyers were advising her to do. Her prior lawyers weren't advising her not to file financial disclosures.
I misunderstood what you were saying.
Okay,
I
all
was
right.
trying to clarify that.
Okay, no.
Understand why I was confused.
Now I do, yes.
Yes.
No, they were not advising her to not file financial disclosures.
You were referring to this alone, not the disclosures required by law. That's
Correct,
what
correct,
the delta
correct,
was.
okay.
And I apologize for that.
All right. The second point I'd like to make is that Essential Community Health managed projects. They did work. Right. They were out in the field doing work. So the committee shouldn't get the false idea that these are just corporations set up for the purposes of transferring money from one entity to another. If Essential Community Health is out there passing out food and knocking on doors and passing out masks in underrepresented neighborhoods and lining people up for vaccinations, it's much more than just a shell. It's an ongoing, active part of the community, and that's what was happening with it. So don't mistake that for a moment. The second most important point that I'd like to make is my understanding is that the overpayment, the mistake made by the state of Florida, was made sometime in July of 2021. These different entities that were set up prior to that happening. So it's not as though, you know, there's some big windfall and then everyone runs out to set up corporations to get money. That's not what happened. And I just wanted to clarify that. Thank you. And one final thing we want to is that they didn't receive their first payment from the state under the contract until April of 2021. And the LLCs were created, these different LLCs were created in March, prior to them receiving that money from the state of Florida on the contract, and prior to receiving any of the mistaken money that the state of Florida sent them. So all of that was set up ahead of time. Committee is telling a story that makes it sound like Trinity gets $5 million and then everybody runs out and sets up these corporations in order to hide all of the money. And that's just factually, and this is a factual dispute that we have, that's factually incorrect. What happened was all of these different corporations were set up prior to them receiving penny one from the Florida contracts. And definitely before July, when that extra $5 million came in. And keep in mind that the state of Florida paid Trinity $14 million. There's a lot of money involved here. It's not just the $5 million. So that means there's another $9 million that's being distributed that's legitimate money, right? That wasn't a mistake. That's a lot of money that's going through these different corporations. But the corporations aren't set up after the fact. They were already in existence when that money started flowing.
Mr. Nani, follow up to that? Chair recognizes Mr. Subramanya for his questioning.
Thank you, Mr. Chair. Counsel for the committee, I was wondering if you could bear with me, if you could actually go through sort of the mens rea, where intent is required through some of these counts or through many of these counts. If you could just walk.
Sure, I'll ask
in
our
public
clerk
through
to
that.
return us to the PowerPoint slide that listed all 27 counts so that we can talk through them individually. So the first 18 counts are the various campaign finance related counts, and some of them have mens rea requirements that require the knowledge and willfulness of the Congresswoman, but many of them do not.
Can I get a copy of this, please? This document
It's
that's,
page 4 of the PowerPoint document you've been provided,
thank you.
and it's just a list of the counts in the statement of alleged violations.
Let's not make an issue of that.
So with respect to the charge that there were conduit funds from Trinity Healthcare Services, in order to find that that was a violation of federal campaign finance regulations, it is not required to find that she had knowledge of that. With respect to the fact that there were improper contributions that were falsely reported as personal loans, to the extent that is charged and is in the statement of alleged violations as a reporting violation, her personal knowledge is not essential to that charge. For failure to properly disclose the loans and to disclose the payments from the campaign to the respondent, those are reporting errors. Those are violations regardless of whether she was aware of them. For the acceptance of improper campaign contributions from her family members, her friend, various PACs, et cetera, to the extent that those contributions were intended to benefit her campaign, they were improper contributions. I do think that in order for her to be held sort of to account for those while they are impermissible contributions that would need to be returned if she didn't realize they were happening. I think for her to be held to account, the argument that the investigative subcommittee has put forward that these in-kind contributions she did have reason to know about. I don't think that's essential to finding that there was a violation, but I do think that is what the charge is. The improper the conduit funds, similar to the conduit funds from Trinity, to the extent that is charged and is charged as a campaign finance violation, her knowledge and intent is not required. Same thing with the additional reporting errors, and the false reports filed with FEC generally. That charge is meant to capture the systemic reporting errors and repeated loan misstatements. Now, charges 15, 16, and 17 are based on criminal statutes, and they do require some level of mens rea where she was had the requisite intent to engage in this activity. So the investigative subcommittee has charged her with knowingly engaging in money laundering with respect to not just the funds that went from Trinity into her campaign and were funneled through myriad different entities, but also with respect to the funds that went from Petrogaz Haiti through the various PAC-like organizations into her campaign. And then finally, the false statements charge, that does refer to the false statements made to the FEC in the reports. A single charge of false statements was brought in recognition of the fact that the ISC found there was clear and convincing evidence that she would know that the millions of dollars that were moved into her campaign were not actually transferred as reported. And then the commingling of campaign and personal funds is a House rule that definitely does not require her personal knowledge, but in that it involves her personal funds, certainly by nature of that would involve her having some awareness. The financial disclosure accounts, on their own, they do not, to be a violation, they do not require any personal intent or knowledge, but the committee's longstanding precedent has been that it will not take enforcement action against members for inadvertent failures to file or errors, provided that when they are made aware of such errors or delinquencies that they remedy them. And then the House rule charges do not require, and the Code of Official Conduct charge don't have any specific mens rea requirement. Those are more generalized ethics standards that have the requirements you read into them.
So you're saying that only counts 15, 16, and 17 require proof of intent?
Those are the only ones that require proof of intent. I think there was intent for others, but those are the only ones that require it.
And what evidence did you draw upon to prove intent in those counts?
In some instances, there is documentary evidence going towards that. So for example, the money laundering of the Trinity funds. We see the text message in which the Congresswoman discusses the money that her sister is giving to her friend that is then going into her campaign. And that is money that her sister had just received from Trinity. And then also the timing and nature of the contributions we think goes to that. I mean, we're not talking about a $5,000 contribution that you may not have noticed in your campaign. We're talking about the bulk of her campaign finances. I think
Of course, that's not money laundering. If that money was her sister's and her sister had a right to it. The staff has presupposed that all of this money is somehow tainted. And that's where we have the biggest factual dispute here. And that's why this is silly for us to try to resolve this with a motion for summary judgment. We need to have a hearing so that you can determine whether or not this money was tainted or not. If it's not tainted money, then none of these counts should be held against the Congresswoman. And you can't determine whether or not it's tainted without taking some evidence on it and giving me an opportunity to call witnesses as well.
I understand. Yeah. And I do want to get to your response to this as well. So thank you. Could you keep going?
Corporate contributions are impermissible campaign contributions. To try to obscure the source of them by sending them through various individuals to be made at the max amount that individual contributions have is an intent to conceal the unlawful contributions.
And then the false statements, 17.
Yes, that relates to the repeated false FEC filings regarding her loans. Just a moment. Respondent has argued that she wasn't responsible for her FEC filings, and so even agreeing arguendo that she wasn't involved with, aware of every misstatement on her FEC filings. That's what some of the earlier charges are meant to get to, the systemic sloppiness of the filings. But this charge is meant to get to the fact that she has repeatedly, for 60 or 61 cycles, reported her loans in a way that does not match the actual transfer of funds in her bank records. And she may not have been the one filing her FEC reports, but that was the money from her account. What her counsel has argued was her personal funds, and what we have argued was impermissible corporate funds.
Okay, I want to give counsel to respond to especially 15, 16, 17, where there's an intent requirement. And I think those are some of the more serious charges as well.
Right, and excuse me. Money laundering is a federal crime, and it presupposes that there is a taint on the money. The money is ill-gotten gains, or the money has been flown through or transferred through some account in order to conceal its source. That's what money laundering is. Every single penny that went into Trinity came from the state of Florida. All of that money was paid by the state to Trinity. Trinity has that money. It's not money laundering at that point, right? Can we all agree that the Florida sending Trinity a check is not evidence of money laundering? Trinity then takes that money that they receive from the state of Florida to do all of these different vaccination projects, and they pay out their expenses, they pay out all their employees, and then if there's money left over, it is distributed pursuant to their family agreement, what I call the profit sharing agreement. Every individual that received funds worked for those funds. There was nobody, and I don't think the committee has competently suggested that there was somebody getting money who wasn't working, who wasn't doing something in return for it. So the idea that the Congresswoman is somehow guilty because Trinity paid out money to those different corporations in the flow sheet is absurd. You would have to come into a courtroom and argue that the money from Trinity was somehow tainted, that it was illegal, or that none of these groups deserved the money, and staff hasn't even made that argument. The Congresswoman was out there working. Everyone else, all of the individuals, including her brother, including her sister, including Nadej, they were all out there working all day. They deserved a piece of whatever, they deserved to be paid for their work. And if they were part of the leaders of Trinity and everyone agreed, then they deserved a particular profit sharing. That's what was happening. And to call that money laundering is based on a false premise that this money is tainted because Trinity didn't deserve to get the money from the state of Florida. And it may be true that Trinity did not deserve to receive that extra $5 million, but Trinity didn't cause that to happen. The state made a mistake. Now, we can talk about whether or not Trinity should have caught it immediately, should have given it back immediately, whether or not it was improper for Trinity to hold on to it as long as they did. before entering into an agreement to prepay it, to pay it all back. Like, we can talk about those things, but when that money flows from the federal government to the state of Florida, from the state of Florida to Trinity, that is all 100% legitimate and above board. And when Trinity distributes it to the different family members and different organizations that the family members are doing work for, that's completely appropriate also. Another member said, well, the dates that these corporations were open, it's problematic. Well, they knew that they were going after these contracts. They knew that all of this work had to be done in the field. The corporations were set up prior to them receiving the money, prior to them being paid. There's no way that this committee could grant a summary judgment motion on these kinds of counts when there is no intent that's been proven. In fact, it hasn't even been proven that the money is tainted and would fit under the definition of money laundering. I understand that there were significant problems with filing the proper paperwork. We get that and we understand that. There's an affidavit from somebody saying someone else was handling 95% of the filings with the FEC. Now, do the committee rules require staff to prove by a clear and convincing evidence that the Congresswoman had the intent to file the wrong FEC files? I don't know. Maybe it does or maybe it doesn't. That's really not the point. The point is she wasn't the one doing that. That was somebody else. We have a factual dispute on that, and I would like an opportunity to be able to flush that out for you, to call in witnesses and to cross-examine witnesses to determine who actually filed these FEC forms that were wrong. Were they doing it under the direction of the Congresswoman, or were they doing it under the direction of somebody that was working for the campaign who claimed they knew how to fill it all out, and it turns out they lied? There's a big difference there. And the only way we can get to that kind of nuanced decision on any of these issues is by having a full hearing. That's what trials are for. That's what adjudicative hearings are for, so we can get to the truth of all of this. Right now, on this record, there's not enough. And especially when you have me now telling the committee that we are factually disputing all of these issues.
Thank you. Council, how does for the committee, how does the straw donor scheme fit into the counts themselves? Do you know which ones those cover?
So the straw donor scheme is not unrelated to the Trinity Funds money laundering scheme because, as I mentioned earlier, the funds that were moved into the sister's account, to the friend's account, into the campaign originated with Trinity, and that sort of moving of it was intended to hide the fact that it was an unlawful contribution. It also goes to the false statements piece because that is one of the clearest pieces of evidence that she was aware of the fact that things were being reported as coming from a source other than who they actually came from.
And counsel for the defendant, how would you respond to that?
The money flowed appropriately from Trinity to her sister, to Nadej, to her brother, to other people. And then those people wrote campaign contributions because they wanted to contribute to her campaign. And that's perfectly permissible.
Do you see the text messages?
I saw one text messages that referred to the limit is 2,900. That's why
the max is 2 checks, so 2,900. This is why sister had to give money to Nadaj for her to make another donation. So when you give money to another person, that's generally to make a donation.
Right. And if we were to read that text message alone without any context and without hearing from the person who wrote it and the person who received it to get a little context, I could understand why somebody would misinterpret it. But the fact of the matter is, I would suggest that the committee needs to take some evidence on that. You need to bring these people in, and the committee can subpoena them. I can request a subpoena to bring them in myself. But let's air this and let's find out what really happened, because that text message should not be read alone. We should know what they were discussing. We should be able to put it in some kind of a context.
And then the other string of text messages, efforts to inflate FEC reporting numbers with loans. Would you say that the same thing about those text messages as well, that we need more context for that?
Yes, I mean, I would say at this stage of the proceeding that we disagree factually with the interpretation that staff has attached to these text messages. And in order to fully understand it, we would need more information and we would need to hear from the witnesses. But right now we have a factual disagreement as to the meaning behind these text messages.
And then is there a factual disagreement about the money from Petrogas Haiti to progressive people to Truth and Justice? This is page 10 of
1,000% a factual dispute, because first of all, because staff has suggested that the Congresswoman has some knowledge of all of this, and she simply did not at all. And if I have to, at an adjudicated hearing, maybe we're going to have to put the Congresswoman on the stand to testify to that. But she had no idea whatsoever that that was happening with those funds during the 2022 election cycle. So factually speaking, yes, I object to those conclusions that were drawn. The money may have flowed that way. I haven't seen the supporting documents, for example, from the Haitian government to the Florida-based corporation. I just haven't had the time to get into those documents, to be honest with you. But whether or not the Congresswoman was aware of the flow of that money, I can tell you that her position is she was not aware of it and would be happy to testify to that at the appropriate time.
Counsel for the committee, how did you reach the conclusions on PowerPoint page 10?
Those conclusions, the flow of money that conclusion was reached on the basis of the clear bank records. That's incontrovertible. This is how the money flowed. As to her intent, the investigative subcommittee did believe that there was clear and convincing evidence of her intent, recognizing that when it gave her the opportunity to testify under oath to that question, she did not do so. Based on the evidence it had, it felt it was enough to show that. There's the fact that shortly before that money started to move from Petrogas Haiti into Progressive People, there are records of her having a campaign fundraising meeting with the individual who owns Petrogas Haiti and his wife.
Let me stop you there. How did you know she had that meeting and that it was about this?
Because of the calendar entry and the text message communications between two of her staffers asking what's this thing on the calendar and explaining that it was a meeting that had been scheduled by someone, and it says
this was a meeting
reception, Petrogas Haiti fundraiser.
This was a meeting with the Congresswoman in Petrogas Haiti and themselves directly, like they met.
That's what was scheduled. We weren't able to question the Congresswoman or the individuals of Petrogas Haiti about the specifics of that meeting.
And I think the defense here is saying that this may have happened, but there was no knowledge of this by the Congresswoman. Could you explain to us? These surrounding factors is what you're saying.
Yes. So what led the investigative subcommittee to conclude that she surely knew about this was the timing of the transactions, the chain of her closest associates who carried them out, including her husband, and the complexity of it. There's clearly some awareness of the fact that this is not lawful.
Councilor Defendant, would you want to respond?
Yeah, so you heard the answer that staff just gave. It wasn't a direct answer. Basically, they're just saying circumstantially, well, it looks like that because of the timing, and it looks like that because it was complicated. And let me just suggest to the committee that the appropriate thing to do would be to bring in witnesses.
We know.
So we can question it.
I do want to add.
This is absurd
Wait, you made that point. I understand.
Okay.
We're just trying to flesh things out.
I understand. And just
for counsel for the committee, you mentioned the term clear and convincing evidence, right? This is what we have to essentially show. Is that right?
Yes, we're not denying that it's circumstantial in certain places, but that it is nonetheless clear and convincing. I think there's one other important factor I neglected to mention, which is that her campaign account was at $0 for a point during this period, and yet there were ads being bought. There were things happening to support her campaign. So either she didn't realize that someone else was paying for her campaign, or she was well aware that these campaign expenses were coming from elsewhere.
These campaign ads, were they were TV ads, or were they, do you know what form these ads were in?
I believe there were TV and radio ads during that time.
So then they would have a marker on paid for, is that right? Like they would show who paid for the ad, right? They would.
I believe that's right. And part of the record is that Truth and Justice paid for ads that had markers that they were paid for by the Congresswoman's campaign.
Would counsel for the defendant want to respond to any of that?
I think it's a question of knowledge. You have an affidavit saying that decisions were being made by other people in the campaign. Give me 1 second, I'm sorry.
And just to be clear, I don't know if it's a question of knowledge on all of these counts, but we're talking about, I think, the most serious counts here, right?
As far as the element of truth and justice,
The affidavit that we've previously submitted says that regarding Truth and Justice, individual one was the only person observed controlling the entity. He appeared to have complete authority over it and explained that it was structured so as to not require the same level of financial reporting as FEC. He indicated that it was used to fund attack advertisements, including one to attack Barbara Sharif. This is clearly an issue of fact for the committee to consider, because according to the person filling out this affidavit, someone else was handling all of that, and it was not the Congresswoman.
Thank you. I yield back.
Gentleman yields back. I'd like to clear up a couple things, and there may be a few other members who have questions. Would like to try to limit the questions a little more. Again, I'm not going to put time limits on this, but I do think it's important for us to try to move through as quickly as possible. Ms. Brazier, you talk about the fact that this was a family business. Is that right?
Yes, sir.
And a family business in which the respondent, she was the CEO of the company.
That's correct.
And she was actively involved in the day-to-day operations of the company?
She was, until at some point, I believe she stepped away for campaign purposes, but primarily, yes, she was involved with the day-to-day operations.
But she was unaware of the $5 million overpayment to her company for which she was the CEO and involved in the day-to-day operations. And which came off of a single invoice, because according to the statement of alleged violations, that the largest single overpayment to Trinity was approximately $5 million in connection with an invoice. The invoice was for $50,578.50. And instead of paying that invoice, Trinity received a payment of $5,057,850, 100 times the amount of the invoice. And so you have described this as a small company. We don't need profit sharing agreements because this is all family. She's the CEO. She's involved in the day-to-day operations, but she fails to notice a payment that's 100 times more than Trinity should have received, and actually a payment 40% in excess of the total payments that Trinity received over the course of the contract. And so I'm trying to wrap my head around this overpayment because the allegations made by the committee is that the overpayments were money, much of which was put into these different accounts, whether it be directly to the respondent, SMC Consulting, EC firm, or others.
Right.
But it's your allegation that she had no knowledge of this and was unaware that they had received a payment 100 times more than they invoiced the state of Florida.
I didn't say she was unaware of the money coming in. She was certainly aware that Trinity was receiving large checks from the state of Florida. She was aware, I mean, they were bringing in millions of dollars, over $14 million, I believe, that Trinity brought in during this period of time. But no, she wasn't sitting there opening the envelopes and reading the checks and signing the checks and depositing the checks into the account. Someone else was doing all of that. When those checks came in, when that big check came in, the wrong one from the state of Florida, she had already stepped aside from Trinity in order to work on the campaign. So she wasn't even there when that came in. She was doing the work for the consulting group, working on the campaign, but she wasn't receiving the financial information every day.
And then as it relates to the chart on page 6, the chart that we referred to, there is directly under Trinity, there is a pink box that has a payment of $200,000. I think that payment is actually just short of that, $198,828. And is it the staff's position that money, and again, that was not a single payment, but those payments went directly from Trinity Healthcare to the respondent's account, and that those payments in and of themselves, the account was unable to receive those payments?
Yes, there were 3 separate payments from Trinity Healthcare Services bank account directly into the campaign's bank account, which were at the same institution.
And then there has been some conversation about the money that the respondent's sister gave to Nadaj, and then Ms. LeBlanc then makes a contribution to the campaign. And you actually reference on page 8 of the materials the body of a text. And just so I'm understanding this correctly, this was a text that was sent by the respondent, not a text sent by her sister, not a text sent by someone else, but a text sent by the respondent that says the max is 2 checks of $2,900. That's why, and we blocked out the name, but the sister had to give money to Nadaj for her to make another donation. Is that correct?
That's correct. It's a text from her to her campaign treasurer.
Now, Mr. Brazier, you said that at some point that your client had stepped away from the family business and was no longer being a part of that, but she continued to receive compensation, did she not?
She did. It's Bar Z. Bar and then Z. Bar Z.
Mr. Barzy, I'm sorry.
That's okay. I wanted to correct it for you.
But she had stepped away, but was still receiving compensation from the company?
Yeah, and in fact, she wasn't even in the same city where the finance people at Trinity were handling all of this. You know, they were all over the state of Florida. They had operations in Jacksonville, in Orlando, in Tampa, in Miami.
Had she stepped down as CEO?
No, I mean, the truth is yes, but she didn't sign any document that said she was stepping down as CEO. But again, this is a family-owned business. What she did was she stepped away from the company, from running the company. The family continued running the company. She wasn't removed as CEO on any official document or something, but she wasn't there on the day-to-day basis. And even when she was there day-to-day, her focus was not the finances. That's not what she was doing. Someone else was running the finances, and she was running the community outreach. She's the one that had the contacts with all the different churches, all the different community groups. She's the one that would go out and hire everyone. She's the one that would help them get out the tents and set up the tents for the vaccination sites. So she's not sitting behind some big desk reviewing profit and loss statements all day. Someone else is dealing with finances. That's not what her role was.
I mean, I would just think if I was CEO of a company and we received 100 times the invoice that we had sent out, that at some point as the CEO that I would be notified of that. But you're telling me that that's not how this family business was set up.
She was notified that the money came in. I'm not saying she wasn't notified. I'm just saying that at some point. I didn't say that. There's just to clarify, she was aware that money came in. She wasn't aware that the money that came in had come in because of a mistake from the state of Florida until much, much later. Do you understand? So that, I just needed to clarify that.
And last question, and then I'll turn it over to the ranking member. As it relates to slide 10, which we've talked about, which was the money that flowed from the Haitian government to Petrogaz Haiti, to progressive people, to Truth and Justice. The flow chart there lists those dollar amounts that came in first from the Haitian government, which was $12.5 million. It then it was then deposited into the Petrogaz Haitian account. They then took a portion of that money, $810,000, they deposited in an account entitled Progressive People, which was an account that the respondent's husband had control over. He then took $725,000 of that and deposited in an account known as Truth and Justice, a campaign account that was controlled by her campaign consultant. And then on the statement of alleged violations, if I'm not mistaken, page 27, there is a chart showing where much of this money went. And it includes vendor one payment $18,000. Her brother received a check from that account for roughly $180,000. Vendor two, $150,000. Vendor three, $24,000. Vendor four, $4,500. Vendor five, $17,000. Vendor six, $45,000. Vendor seven, $96,000. And then her campaign manager was paid $25,000 out of that account. And is it the position of the committee staff that these vendors provided services to the respondent's campaign, and that those services that they provided to the campaign were paid not by the campaign account, but were paid out of the account titled Truth and Justice?
Yes, to some extent. Some of those vendors were also paid by the campaign for certain amounts, but other campaign expenses incurred by her campaign were paid by Truth and Justice to those vendors.
So some were paid duly. Some were paid by her campaign and then also paid by Truth and Justice.
Yes, particularly when she ran out of money in her campaign
And
account.
were those invoices, from your viewing the invoices, were they billed to her campaign?
Some of the invoices were billed to her campaign. Some of them didn't involve formal invoices, like her brother.
With that, I will yield such time as the ranking member may consume.
I'm sorry, can I just respond to something that staff said? I apologize, just quickly. The important thing here is that progressive people, there's no evidence that progressive people is right now in the record before you. We have not heard from the respondent's husband related to what his knowledge was of where Petrogaz Haiti received those funds. So to put this on a chart saying that the money is coming from Haiti and suggesting that the congresswoman who's 6 or 7 steps down somehow has knowledge of that is absolutely unfair. We need to get somebody in order to establish whether or not Petrogaz understands where that money is flowing from, whether or not Progressive People PAC knows that the money from Petrogaz was originated in Haiti, and that evidence is not before this committee right now. Finally, the money going into Truth and Justice, which is being run by a campaign consultant who the affidavit tells us was handling 95% of all of this. So as far as the congresswoman is concerned, whether or not these things factually happen the way this flow chart suggests, I'm not sure. But did she have any knowledge of it? And did the people in the flow chart who were receiving the money know where the money was coming from upstream? We don't have an answer to that without calling witnesses. So if the committee wants a finding on summary judgment to suggest that the congresswoman has violated some law or some rule of the House, at least let her talk to these witnesses who are making these claims. Allow us to cross-examine them to determine what the truth is, because the fact of the matter is this flow sheet on page 10 doesn't show anything other than some pretty boxes. It doesn't tell us what anybody knew. It doesn't tell us about the knowledge of where these funds were coming from.
The individuals that control the accounts were her husband and her campaign consultant. And I'm assuming that your client knows those individuals.
Yes.
Would committee staff like to respond to anything brought up?
I would like to note that I would refer you to pages 23 to 27 of the statement of alleged violation, which lays out extensive evidence of how the scheme was carried out, including details of her husband's testimony that he just couldn't remember why the 90% of his company's funds went to this organization, Truth and Justice, and where it came from or what it might be going towards. I think the evidence is there, and we've already laid it out in detail. He has, however, raised questions about whether it's fair to say that she should have known that Truth and Justice's funds were going to benefit her campaign. And he's relying on this affidavit that he introduced just before the hearing from a staffer who the committee also interviewed. He has said that staffer says that individual one, Mr. Mark Goodrich, was the one who decided everything that Truth and Justice was doing, and that the Congresswoman didn't know about it. We're not disputing that individual one was involved in making those determinations, but his testimony is that the Congresswoman knew about it. And the staffer cited in the affidavit, when asked if she'd heard of the company Truth and Justice, testified no. Now, yes, this is a fact issue that has come up last second just before the adjudicatory hearing, but at the time, it's not material because it's evident that the funds were used to support that, and that she had ample reason to know that the funds were being used such, and it strains credulity to suggest that she didn't know how her campaign was being funded.
Well, this is why you take testimony, because we don't have to just make arguments about, well, it's strains credulity because she must have known. Let's call witnesses and let's have a hearing and find out the truth. There's also a suggestion that these things were being done because the campaign was out of money. The campaign wasn't out of money. The campaign was spending the money as it came in on TV ads and other things. The Congresswoman had her own personal accounts. She would make loans to the campaign when it was necessary. So this type of outside spending that individual number one was engaged in was being done independently of her knowledge. She had no knowledge of it. So how can we hold her responsible if the only link to her is, well, she must have known, without having any concrete evidence before you? This is why I'm saying the idea of ruling on a summary judgment motion when something is at stake, like a member's career, is a mistake. Let's have some witnesses in here and let's figure out exactly what happened, rather than asking staff what their opinion of circumstantial evidence is and whether or not it makes them credulous or not.
Let me just follow up on something committee staff, and then I will yield to the ranking member. You talked a little bit, Brittany, about this affidavit that Ms. Luster filled out. And then you also talked about the fact that committee staff had interviewed individuals with Truth and Justice. Was Ms. Luster one that, has she been interviewed?
Ms. Luster wasn't with Truth and Justice, but yes, she was interviewed, as were the two individuals involved with Truth and Justice.
All right. And when you talked to Ms. Luster, what statement did she give the committee, if you recall?
She did not know what Truth and Justice was, is what she told us.
All right. And then you interviewed two other individuals who were associated with Truth and Justice?
Yes, we interviewed the individual who is listed as sort of the president of Truth and Justice on the filings with the state. He indicated that he just understood it was a vehicle to make expenditures for her campaign. We interviewed individual one, who was her campaign consultant, and he indicated similarly. The SAV discusses in detail some of his testimony, and he also spoke to her direct knowledge of what was going on.
So Ms. Luster said she was unfamiliar with Truth and Justice when she spoke to the committee before giving this affidavit. And individual one, who she references, the committee spoke to individual one, and his testimony before the committee, was that testimony under oath?
Yes.
That his testimony under oath before the committee was that the Congresswoman knew that the funds flowing from Truth and Justice were being used to benefit her campaign.
Yes.
I recognize the ranking member.
If I may, he said it under oath. It wasn't tested. And you know how we test the truth? We test it with cross-examination. It's the greatest way of testing whether or not a witness is telling the truth or not. You haven't even had an opportunity to ask him any questions.
I did not serve on the investigative subcommittee, and so that is the staff and the members of the investigative subcommittee. But I wanted to make the point that he was placed under oath, and so he is subject to perjury. Now, could he have lied? Clearly, he could have lied. But if he lied to the committee and now comes and makes a contradicting statement, he would be subject to perjury. And so it's not just a statement where we called someone on the phone and they gave that statement. That statement was actually given under the penalty of perjury, and that individual gave a sworn statement under oath before the committee. And so I do think that is important and an important distinction when we're talking about statements that are given. And clearly the statement that Ms. Luster gave, according to committee staff, contradicts the statement that she gave. Was her statement under oath?
It was not under oath, but she was informed it was subject to the False Statements Act.
And we dispute the statements that he made under oath, regardless of whether or not he made them under oath, regardless of whether or not another subcommittee heard that statement. We dispute that. We disagree with that. We don't believe he was being truthful when he made that statement. And therefore, I think the appropriate thing is to allow me to have an opportunity to cross-examine him, because that's how we've done it for over 200 years in this country.
Recognize the ranking member.
Thank you. Mr. Chairman, Mr. Brazier, I'm struggling with
Barzee.
Barzee, I'm sorry.
That's
Nobody
okay.
pronounces my name correctly. I'm struggling with some of what I see as inconsistency. So I'm not a lawyer. I own family business. So a family business to me isn't $14 million. It's smaller than that. If I had $14 million, and especially if it was family, I wouldn't have this as a legal document for profit share.
I don't disagree with you at all, sir. Neither would I, but the way that you and I would handle a business is not the way everyone handles a business. And in the Congresswoman's community, in the Haitian American community, it is not unusual for these types of agreements to be made orally, to be made with a handshake, to be made with family trust. And I know that that's not the way we all do it. Everyone's different. And the best way to get to the truth of that, sir, is to allow me to call the witnesses and have them testify in front of the committee.
Now, I realize you're new to the process, but we're a little impatient, I think. We're tired because we've been at this in the ethics committee and the subcommittees for 2 years, and your client, represented by other attorneys, has not been responsive. If I were in that position, I would have brought payroll records. I would have brought tax records from the state of Florida and other things to prove that you actually had business expenses. But the absence of that sort of makes me sit here and go, this strains credibility that you could say, oh, it's just a family or it's a different community. I'm being honest with you. It's hard for me to take exception to that because, and we said this a lot at the beginning, this is not a courtroom. This is the ethics committee.
Right.
So I'm just telling you honestly, it strains credibility. And if I had this kind of money and I was running for Congress, I would have, on the FEC, I would have hired a compliance company. So all of those things, having walked in here with an open mind, is straining credibility. And if I was looking at a financial statement in a family business, I would notice $5 million
Right.
worth of, if it was the other way, I'd sure as heck notice it. So I'm just being very honest with you.
And
This strains credibility.
I
from my
appreciate
perspective.
that. I appreciate that. Not only do I appreciate it, I concede that it raises very significant questions. And my point to the committee is, instead of guessing as to what actually happened, instead of guessing what these motivations were, just give me an opportunity to call witnesses and to have them address you. I understand the impatience. I understand it's been going on 2 years. I understand that the other councils handled the case differently than I would. But if you give me an opportunity, I can call these witnesses and we can answer your questions and have them explain it to you. I'm explaining it the best I can, third hand, based on what I've learned in the past 21 days. And what I'm saying to the committee is, if you want to really understand all of this, if you really want to understand it and get to the truth of it, there's only one way to do that. And that's by calling in these witnesses and questioning them under oath and giving me an opportunity to cross-examine the staff witnesses and giving staff an opportunity to cross-examine my witnesses. And that's how the truth will
I
come
would agree
out.
with that, but part of our charge is to protect the reputation of this institution. And it's already been eroded by your client's action, at least in the public perception. If we're being honest and truthful and we're trying to give her the benefit of the doubt, we're already eroding that trust that we have a responsibility to adhere to. So I'm just being perfectly honest with you. It's not making sense to me at this moment. And in the context of, just let me explain now,
Hold on.
what happens if this happens again? If we were to have granted the continuance, I don't know. I just assume that we're going to be back here in 6 months going through the same thing. So that's just my observation. It's more of an observation. I'll give you a second to respond, but only a few seconds, please, because I know we're all tired.
I mean, when okay. Some context. Trinity has been in business for over 30 years. They're a successful company. They made a lot of money. Some years, 1 or 2 million, other years, 4 or 5 million, sometimes more than that. But it's a corporation that has been in existence for a long time. It's an old family company. At some point, her father gets COVID, he gets sick, other people are moving in to take over things, and they come to an agreement. We're going to start dividing up the company. We're going to divide up profits. And that's the profit sharing, what I called evidence of the profit sharing agreement. I understand the members' concern. I mean, I get it and I understand it. And the only way that I think could possibly be done to explain it is by calling in these witnesses and talking to them, because we're not going to be able to judge their credibility or understanding based on some paragraphs in a report that were written up by staff. Not for something this serious. Not for something this serious. And I get the fact that that the committee has been dragged along for a long time and that there have been difficulties in getting this case moving. I concede that and I understand that. And I appreciate the patience that the committee has shown me personally. But the fact of the matter is, at the end of the day, if we want to know the truth, rather than just go by our feelings, the way to do that would be to call witnesses and to bring in witnesses, put them under oath, and let us ask them questions. That is the key. There is a reason why the justice system and trials is considered the gold standard all over the world, because of every single different system that's come up with trying to find the truth. The one system that works better than all the others are trials.
Counsel, I just had some observations. You've been very eloquent about your position. This doesn't come from me from just feelings. It comes from an objective business analysis. I've gone over hundreds, thousands of business statements. I own businesses. I did consulting. What we have here is no evidence of where the money came from or went and what services were provided. We've had over 2 years to have the client to be able to do that. I'm just expressing my opinion. I wanted to give you an opportunity to respond. It's not, there are some feelings here because we're tired, but objectively looking at this, especially with families and two people who are attorneys or went to law school and were attorneys, you don't go into agreement with that kind of money based on how you're going to divide things, especially with families, based on this as a revenue sharing. So that's my comment. I'll yield back.
Thank you. I don't think, oh, I'm sorry, I'm sorry. Go ahead.
Gentleman yields. Chair recognizes Ms. Henson.
Thank you, Mr. Chairman. My question is again for committee staff, and I'm just going to reference some things from the statement of alleged violations because I think we do need to talk about the truth and the numbers here. How many times did the investigative subcommittee meet?
So many times that I need to look it up. Just one moment. 12 times over the course of 2 Congresses.
Okay, and how many requests for information did that subcommittee send? to
30.
Respondent. 30.
To respondent, 3.
3. But there was a very good information gathering effort here over a significant amount of time, correct?
That's correct.
Yes. How many subpoenas were issued?
59.
59 subpoenas. And over 33,000 documents?
Correct.
So the lack of candor charge, then this is going to be my last point here. Can you lay out and talk about how that response and lack of response from the respondent directly ties into that lack of candor charge?
Yes. So for 2 years, the committee, the investigative subcommittee sought information from various witnesses, including respondent. Respondent, through her various attorneys, did not provide no documents despite the Fifth Amendment concerns that counsel has identified. She did hand over about 2,000 documents of varying degrees of relevancy, responding to various requests, but she also completely ignored various of the requests from the investigative subcommittee. So the investigative subcommittee renewed its requests and narrowed its RFIs to try and make it less burdensome as she started to cite concerns about the cost of responding to it. At a certain point, the counsel for the Congresswoman said she's going to decline to further respond to these requests for information. So then we asked, this is in November 2024, is your client going to assert her Fifth Amendment right against self-incrimination? Counsel said, we're not saying that right now. We think that it's just too burdensome to respond to all these requests. And we said, okay, we'll narrow it further. And we came up with a narrower set of requests. They did not respond to that. New Congress came around. She moved on from that counsel during a period of time when she was unrepresented. We had a difficult time contacting her. Eventually, a new investigative subcommittee was impaneled and a new request for information was sent out, reiterating the narrowed requests that were outstanding. And about a month after that, her third counsel in the matter appeared, and we explained what was outstanding. We walked him through what we were missing. We again asked that he please let us know if she's going to assert her Fifth Amendment right against self-incrimination. And we let him know at that time that we were also going to be seeking her testimony, that the ISC had authorized a request for her testimony. After several months of back and forth and trying to negotiate and come up with a timeline that would work for counsel and accommodate her schedule, there was a voluntary interview scheduled, but she canceled that last second. No documents were produced during that time. Eventually, the ISC was brought to the point that is rare to have to do to their colleagues, but they subpoenaed her documents and testimony. She was the day before she was scheduled to appear for her subpoena deposition. She informed the committee through her then counsel that she would be asserting her Fifth Amendment right. So the deposition was canceled.
And here we are tonight. All right. Thank you. That's the only question I have. Do you have a response to this complete lack of candor charge? And obviously it's counsel before you, but here we are tonight. And this is why we are having the conversation about moving ahead with this subcommittee hearing.
And what I heard was that the Congresswoman was communicating with the committee, that the Congresswoman had turned over thousands of documents, that the Congresswoman had attorneys communicating on her behalf with the committee staff, that they had agreed to set up an interview. This doesn't sound like a lack of candor to me, with all due respect.
When your client canceled said interview, that doesn't sound like lack of candor.
No, because she has a Fifth Amendment right under the Constitution of the United States to remain silent. And when push came to shove, she invoked that Fifth Amendment right.
She did not show up to the committee, though, to say, I am invoking my Fifth Amendment right, correct? She
So
just
let me
answered-
understand. So the allegation of lack of candor is that she didn't physically walk over across the
I'm-
street?
Committee staff just detailed the reason why the lack of candor charge exists. It's a multiple year, I guess you'd call it, systematic effort to avoid compliance with committee, fully complying with committee.
Which is
So I-
nonsense, because that's not what happened. You just heard that she turned
Clearly,
over thousands of
Sir,
documents.
this is my time. I am saying what the committee staff just laid out was a very clear pattern of dilatory tactics and a direct non-compliance with their requests and with the investigative subcommittee request, which is why we are all at this point tonight where we are moving forward, because frankly, the House Ethics Committee's job is to protect the dignity of the chamber and make sure our members are meeting that requirement that we all agreed to in the House rules. So that is why we are here tonight. I just wanted to make sure it was very clear that that pattern was laid out for the record. Thank
Oh.
you, and I yield back, Mr. Chairman.
Gentlelady yields
May I
back.
respond, please? What's clear is that you want to hold her, you want to call her invoking the Fifth Amendment right a lack of candor, and that is inappropriate, and
I
that's
call
what
lack
you're
of candor-
doing.
Sir, lack of candor is the evidence that this staff has just laid out of a pattern over the course of the 118th and 119th Congresses of not complying with committee requests. That is the lack of candor. Thank you. I yield back.
The gentlelady yields back. The chair recognizes Mr. Ivy.
Thank you, Mr. Chairman. Okay, as promised, I want to go to this document. This is 2022 reelection funds. And I know there's been some questioning and comments about it, but I wanted to sort of follow up. Does this document link to the money laundering charges?
Yes, one of the charges relating to the Petrogas Haiti funds.
All right. And what is that, 16? Count 16?
Yes, 16.
Okay.
Sorry, yes, 16.
All right. So the Petrogas, I think you said earlier that this is evidence of misconduct. You talked about the complexity. Shows it was clearly unlawful. I think that was a quote. Those are my notes anyway.
Sounds like something I'd say.
Sorry?
Sounds like something I'd say.
Yes, ma'am. Campaign finance reform meeting with head of Petrogas Haiti.
She had a fundraising meeting with there are documents that indicate she had a fundraising meeting with the head of Petrogas Haiti shortly before the money began to flow into the organization affiliated with her husband.
Okay. And that demonstrates, how does that support the claim of money laundering? The meeting?
It's evidence that she likely knew what was happening there, combined with the other evidence, the timing of the proceeds, her involvement with all organizations in the chain. She was also providing money to Truth and Justice, Inc., and her campaign consultant was doing it. And then the fact that the people involved were so close with her and the sheer amount of money involved would be hard to go unnoticed. Those were the factors that were considered in determining that there is enough convincing evidence that she must have known what was going on.
Well, the what was going on part is what?
That Petrogas Haiti was contributing to her campaign through shell corporations run by her closest associates.
All right. So Progressive People, Inc., that's the money goes from Petrogas Haiti to Progressive People, Inc.?
Correct.
Okay. And are you saying that was a shell corporation?
It was a corporate, I use that term to refer to a corporation created for the purpose of receiving this money and funneling it into another one.
Oh, well, by shell corporation, I take that to mean that there was no other legitimate purpose for it.
Almost all of their funds went to Truth and Justice. Almost all of the funds they got came from Petrogas Haiti. There were a few other funds they got from.
Okay, but shell corporation is a very tight definition, right? Are you saying that there was no other purpose for Progressive People?
All I'm willing to say based on the record before is that it was the overwhelming and primary purpose of the organization. Shell Company was my word that I threw in there. It is not what appears in the statement of alleged violation. I think that the IC was most comfortable saying that this was the purpose of creating this organization and moving money through it.
Okay, and who said that?
I'm saying the investigative subcommittee felt comfortable arriving at that conclusion.
Oh, I see. Is there a witness or a factual basis beyond that, that this was a shell corporation or that was the purpose it was set up for?
Not other than what I've described, the fact that all of the money, most of the money came from there, most of the money went out into the other organization where we did speak with the witnesses. So there were two people with each of these organizations, Progressive People and Truth and Justice, sort of running things. The two people involved with Progressive People were her husband and an individual named Michael Joseph, who did not comply with the subpoena. Her husband spoke with us, and his testimony is recounted in the SAV, and we consider that evidence that goes towards the convincing conclusion that she must have known about this. Truth and Justice is run by the individual involved with her campaign and another individual, both of whom testified clearly about they didn't know about the Petrogas Haiti source of things because it was another entity over, but they knew the money was going into the campaign and that was its purpose.
All right, and then the Truth and Justice piece, that's the 725,000 comes to them.
Yes.
And then they made payments to campaign vendors?
Yes, that's the chart the chairman was discussing.
Right. And what was illegal about this chain of,
So
what was
those are in-kind contributions. They were made on behalf of her campaign. Rather than her campaign paying the vendors directly, this organization paid the vendors. The money that was used originated from Petrogas Haiti, which is not a lawful campaign donor.
okay. So the payments to the campaign vendors was, you said, a in-kind campaign contribution?
Correct.
And not an actual financial payment for services?
It's the services are real. They're the in-kind nature of the contribution. Truth and Justice bought the campaign ads, the graphics, the various services and goods provided by the vendors for the benefit of the campaign. These were ads for her campaign and other things sort of requested and sort of explicitly set up for her campaign.
Okay. Well, a couple things quickly there then. So the unlawful activity was the fact, testimony or the position of committee staff was that because it came from Petrogas Haiti.
Yes, a corporation which cannot lawfully donate to a federal campaign.
All right. And then the attempts to conceal, which is one of the other elements of money laundering, was what?
Moving it from Progressive People into into Truth and Justice. So these are it's an attempt to create a sort of dark money chain, one might call it. Rather than having to report these things as you would if it went through a campaign or even an actual PAC, it was passed through various organizations so that the source of the funds could be far divorced from the actual expenditures. Further, I sort of lost my thread on something, but I think that's the gist of it.
Okay. It's been a while since I've done a money laundering case, but my recollection was that there had to be explicit proof that the unlawful act was separate from the actual final transaction and that the movement of the money wasn't done to complete the act of the unlawful contribution, that there had to be then steps taken beyond that to conceal the funds. Is that your understanding?
Yes, so there needs to be the unlawful activity and then the proceeds of that steps have to be taken to conceal that. The steps here were creating these organizations, creating Progressive People, transferring the funds from one account to the other, and then having the items paid through that. The other evidence of the awareness of that includes the documents that were flowing. There was generated were these solicitation letters from Truth and Justice to progressive people asking for the funds at the request. There's testimony that it was her husband's idea, but he did deny that, to create these letters where Truth and Justice requests the funds to sort of create a paper trail, making it seem like these are contributions towards what they were styling as a get out the vote operation, but no such operation has been evidenced.
Different question. So is my recollection is that there has to be a distinction between the completion of the unlawful act, which I think you said was the sending of the money so that from Petrogas to pay the campaign vendors ultimately.
The solicitation and acceptance of a corporate contribution is an unlawful act. However, the money laundering statute is a little narrower than that, and the specified unlawful crime that can be captured under that, it more traditionally includes things like fraud. The investigative subcommittee did not go so far as to charge her with fraud here. This is an area where I think you need to recognize the subcommittee's role here to determine whether she was not necessarily, regardless of whether she was in violation of the money laundering statute by beyond a reasonable doubt, as the Department of Justice may have to prove, she was not upholding the laws of the United States and was a party to their evasion through her involvement in this scheme.
Well, no, there are two separate pieces to what you'd have to show to prove money laundering. One is that there was the unlawful transfer, right? And so that would be the movement of the money from Petrogas Haiti ultimately to the campaign vendors. And then the second piece is there were steps taken to conceal the transaction itself.
Yes.
So for example, like in a fraud, the movement of the money I was taken from let's say it's a credit card fraud, and the person takes the money and then deposits the money in his bank account. That's not money laundering because
Yes.
it's not an attempt to conceal.
Yes,
If
she
he
was-
did something to move it away so that it couldn't be seen, that would be the attempt to conceal. So what I'm trying to narrow down for you, just to make sure I understand what your argument is on this, is that the separate attempt to conceal, separate from the unlawful movement of the money to pay the campaign vendors.
Yes, so there's the unlawful movement of the money that is the attempt to conceal, but the unlawful act is a solicitation and acceptance of a corporate contribution. The money laundering aspect is what's been
That's not what
charged.
you said earlier. What you said earlier was the unlawful act was taking the money from a foreign contributor, which is
No, a
Petrogas.
corporation, not a foreign contributor. I want to be very clear. The
Okay.
committee has not, and is not suggesting that it has the evidence to show that she knew that Petrogas Haiti got all its money from the Haitian government, but that she did have reason to know that Petrogas Haiti was a corporation who could not donate to her campaign.
Okay.
So it was solicitation and acceptance of an improper campaign contribution. My point about the code of ethics charge is that you don't need to procedurally find that the criminal law of money laundering has been proven by a reasonable doubt under those standards. She has been charged with failing to uphold the money laundering laws and being a party to their evasion.
Under the,
Code of ethics of government service. We're not the Department of Justice.
okay. So that part of my recollection at least of the money laundering proof is not applicable here? So we can say there's a money laundering violation, but not meet the elements of money laundering?
I think if you felt that she was not upholding the money laundering laws and was a party to their evasion, that is within your discretion. I'm not saying I don't think the elements of the money laundering charge were brought, but I do think it is a lesser standard than proving a crime. That is not what we are here to do today.
All right. Counsel, what your thoughts on the
I mean,
laundering
the
aspect?
committee hasn't offered any evidence that she had any knowledge of this. What they've done is put up a highly prejudicial, false flow sheet here saying that $12.5 million came from the Haitian government. If I heard correctly, they're saying that they're not able to prove that up, that the money came from the Haitian government, or that they're not able to do that at this time. And if that's true, then that shouldn't be on this flow sheet. They shouldn't be trying to paint her with something that they can't prove, number one. And number two, it sounds like their only evidence that she had any knowledge of any of this is that she attended a fundraiser or something with some individuals from Petrogas the day before this happened. That's their proof that she was aware of it, that she decided, that she made a conscious decision not to enforce not to support the money laundering laws in the United States?
This, on that point, which paragraph in the complaint or paragraphs go to the knowledge issue with respect to the campaign fundraising meeting with Petrogas Haiti?
So, one moment. So the motion for summary judgment discusses it on pages 15 to 16. The statement of alleged violation lays out all of the evidence relating to the scheme, which,
Well,
I'm just a moment.
if you go to count 16, you reference previous paragraphs. Because the ones under count 16, paragraphs 378 through 381 are summary paragraphs, and I'm not saying there's anything wrong with that, but they're not making factual allegations that go to the issue of the campaign finance event with Petrogas Haiti. Where would that be discussed?
So the evidence I discussed that was considered in arriving at this conclusion regarding the timing of the payments, the complexity of the scheme, the individuals involved, including her husband, and there's also details about what was said on some of the checks at issue. They range from paragraphs approximately 160 through 180, and they include what I've been discussing here today.
$160 to $180?
Yes, that lays out the scheme as presented.
Where does it reference? Oh, there it is. Let's see. That's 179, 178. 176? Is that where it first references Petrogas Haiti?
While I think there are earlier references, that is the first reference to where it appears in this particular discussion of the scheme.
Well, that's the first point where it says they got the money from.
Yes, so after laying out how
Government of
progressive
Haiti.
people operated, it begins to talk about where they got all their money from.
And where does it reference the Congresswoman?
The Congresswoman who's referred to as respondent throughout here is referenced indeed at paragraphs 178 when she met with the Petrogas Haiti owner. And then other than that, she's mostly referenced in terms of her connection to the individuals involved. There's also some references to her campaign throughout.
Okay, so the company hosted a reception for her, and she met personally with the owner of the corporation and his wife prior to the reception for a meet and greet organized by Mr. Joseph. And then after she got elected to Congress, the son of this owner became an intern for her?
Yes. Yes,
All right. So this was a meet and greet.
that's what it was styled as on the calendar entry. We have not been able to receive any testimony from her or anyone who was present at that.
Okay. So, well, it wasn't a camp, was it a fundraiser or not?
Exhibit 8 to the motion for summary judgment includes details about it. It's referred to as a Petro reception organized by her leadership PAC treasurer shortly before a Holland and Knight reception. So I apologize if I misspoke. The word fundraiser does not appear in that particular instance. However, she did receive the Holland and Knight event is also referred to as a reception, and she did indeed receive a campaign contribution from Holland and Knight around that time through lawful channels.
From who?
Holland and Knight's PAC.
From who?
from Holland and Knight's PAC, a typical PAC
Holland and
contribution. Holland and Knight, the law firm. So
Law firm.
in Exhibit 8, the same day, there's two things called a reception, the Petrogas reception and the Holland and Knight reception. Holland and Knight made a lawful campaign contribution through their PAC around that time. There is no lawful campaign contribution from Petrogas Haiti around that time, but there is the flow of funds into the organization controlled by her husband.
Okay, so the Holland and Knight contribution, do they represent Petrogas Haiti or no?
No, I believe these were two completely separate events on the same day. One was at 12 p.m. at a restaurant, and then the Holland and Knight reception was later that day at 5:30 p.m.
Oh, okay. All right. And then with respect to the false statements, count 17, and I appreciate the time, Mr. Chair. Where is that? Let's see, that's paragraphs 382 through 386. Of the statement. The SAV.
Yes, that's where the charge appears.
All right. So, and you were saying that there's a knowledge and intent requirement for this one?
Yes, the investigative subcommittee determined it was appropriate to bring a false statements charge for really the sum of the campaign misconduct that was talked about before in some ways, because much of what we've been discussing led to false reports. But in the charge, what's specifically discussed is the continued false assertions with respect to her loans. And there is detail in the SAV about how, despite efforts by when she hired a professional consulting firm after she got to Congress in 2023, efforts by them to get access to some past bank accounts, they never were able to, and they never were able to audit and correct the errors from prior to when they took over. The loans continue to appear on your campaign finance filings each quarter until they are fully paid off. So that is one of the main bases for that charge. I do think the investigative subcommittee felt that there was sufficient evidence as a general matter that she had the sufficient mens rea to have been a party to the misstatements in her FEC filings, the intentional misstatements. And I would point to that straw donor scheme and the reporting of the contribution as coming from one individual when in fact she knew it came from another, as yet another example of that.
All right. So when you say, and this is in paragraph 384, numerous FEC reports,
That's the 60 reports that have been talked about a few times.
the how many?
The 60 reports that have come up a few times.
Okay. So all of those are, well, is the allegation of false statement connected to specific of those 60 or some combination of them?
All of them. When your campaign takes on debt, there is a section of your FEC reports where you have to continue to report each quarter, including noting what repayments you have made and what it was from. So every quarter since she began reporting making loans to her committee, she continued to report that debt in a manner that was false.
Report which debt?
The debt relating to her personal loans. There are inaccuracies laid out and discussed already with respect to how her personal loans were reported. They do not match her actual finances, including after she brought on a established compliance firm, and despite their efforts, they were unable to get access to the older bank accounts. There was some testimony about how perhaps there was some bank error that made them have to close those accounts just before the professionals got on board. But in any event, she has never at any point corrected the numerous errors in her campaign finance reports, including to this day.
All right. Well, when you say the numerous errors,
She has about 20 different loans, and she reports repayments on those loans. And so it's laid out in the SAV. Many of those loans are not correctly reported, whether by the source, the amount, the date. Many of the repayments have not been accurately reported. The loans are not accurately described in her
all
FEC
right,
records.
and that continued into the period when she retained or hired professional staff to handle these documents and filings? Is
Yes,
that right?
continues to this day. She still must report all outstanding debt and the repayments made on it.
So the evidence that it was intentional, especially given that it continues now, is what?
That it's that she's saying that she herself made personal loans to her campaign. The investigative subcommittee feels that it is clear that she has every reason to know whether she did or did not actually give or get back money from her campaign in a manner that reflects the campaign reports. But moreover, this has come up since she has been a member of Congress. She has been aware that she has had more than enough time. She herself has produced campaign bank records to us that do not mirror the FEC records that have been filed. Moreover, the investigative subcommittee believed that this was all part of the plan.
So you're right. Basically, your position is that we should infer that she knows it was false.
Of course, we don't have a document where she says, I know these FEC records are false. We do have documents where she is involved in discussing things relating to her loans that she knew. For example, there's the document we looked at earlier about the I'm reporting. She was not on that document. There was the document she was on about how I'm putting this into leverage, and her campaign consultant says, well, no one needs to know that. And then there were the documents that we have. I will grant that she's not on it, but there is the document between Individual One and Nadej in which they discuss that they're going to be reporting more than $1 million. And then we laid out previously in our presentation how they did indeed report contributing more than $1 million in loans, but actually at that time there had not been a contribution of any kind, and then shortly after that there was a contribution of only $400,000, and she didn't amend her FEC reports to reflect that until the FEC noted an issue with the cash on hand. And in that message, Nadej says to Individual One, oh, we're going to be reporting less than our primary opponent. We only have $27,000 in the bank account, which, hey, she had $27,000 in the bank account, not the more than $1 million in campaign loans that were reported.
All right. So which paragraphs in the SAV relate to paragraph 384?
One moment. It's also slide.
Mr. Ivy, not trying to limit your questions, but if you could wrap it up here shortly for the remaining members to ask their questions.
Fair enough. I'll stop after this one.
Mr. Ivy, I also wanted to clarify with respect to the false statements and the loans. It also relates to loans that were reported as personal loans of the candidate, but were actually, for example, funds that came directly from Trinity, that came from EC firm after the separation agreement, effectively loans that she had reason to know she had not made, but were reported as personal loans, as well as some loans that were made that were not made, but were reported as having been made based on the bank records, and other related misreporting errors surrounding the entirety of the loans during the campaign.
All right. And is that in the paragraphs that your co-counsel referenced a minute ago, or is that in a different place?
I will let her respond.
Okay.
I can't point to the exact paragraphs for now. All of this information is indeed in the statement of alleged violation, which sort of chronologically lays out her campaign finances with respect to what we were discussing.
All right.
And
In this, recognizing the time, and I apologize for running so long, but I did want to give counsel a chance to respond before I yielded back. So
well,
please.
I just think it's important to recognize that there's still no evidence before the committee that the Congresswoman had direct knowledge of any of this, number one. And number two, as far as the continuing to make false financial disclosures, all of that is based going back to the premise that she wasn't entitled to the money from Trinity. She's allowed to make loans to her own campaign. There's no question that that's a permissible thing for a member to do. And it is our position that that's exactly what she was doing. The rest of these arguments are all based on a theory that is not proven. And that theory is that somehow the money from Trinity is tainted, and therefore every document, every financial report that's filed, every financial disclosure that's made, we can say it's 61, we can say it's 620. It doesn't matter. It's all based on this idea that just because it flowed from Trinity, it is de facto tainted. And frankly, there's not enough evidence before the committee for the committee to accept that as real. That's along the same level of persuasiveness as saying, well, she had a meet and greet with somebody from Petrogas, so that means she knows that Petrogas went into an illicit agreement with someone else to transfer funds to another corporation to then support her campaign, even though there's absolutely no evidence that she had any knowledge of that.
All right, I yield. Thank you, and I yield back.
Gentleman yields. The chair recognizes Judge Moran.
Thank you, Mr. Chairman. Very briefly, just want to make two clarifications for the record. Mr. Barzee, throughout today's hearing, has said on multiple occasions when he referenced the statement of alleged violations that this is, quote, staff's opinions. He's made that comment and used that phrase several times. Just want to point out to everybody watching, remind the folks on this dais that these are not staff's opinions. These are the findings of an investigative subcommittee made up of members of Congress after several years of investigation. That's point one. Point two, I think Mr. Barzee summarized best, probably better than any of us today, the totality of the response and the evidence that he's presenting today. And he said, quote, I'm explaining it best I can third hand. Triple hearsay, I will remind everyone on this dais, triple hearsay testimony by legal counsel is not and has never been credible controverting evidence in a summary judgment hearing before this body or any other judicial body to my knowledge. And though he has made artful attempts to take us down several different paths, in my opinion, I see no evidence presented that would controvert the evidence presented by counsel for the adjudicatory subcommittee. So just want to make sure that those comments were made on the record before I wrapped up my time. I yield back.
Gentleman yields back. Chair recognizes Ms. Garcia.
I don't have any further questions.
Chair recognizes Mr. Knight.
Yeah, just briefly, and I want to echo some of the sentiments that, given this hour, I too find it hard to maintain a level of credibility from the respondent. Counsel, you stated that she was ordered not to participate in this investigation. That was justification for her not taking part for roughly 2.5 years. You've also made the claim that she was actively participating, giving thousands of pages and so on and so forth. And while she refused every step up until this point to engage with staff, to respond to subpoenas, to produce and explain, canceling interviews with no explanation. Now you're saying you want the full court press, you want witnesses, you want to have your own subpoenas, you want to put the full weight and vigor behind the defense for this hearing. It's both sides of the coin over and over and over. We have allowed you extra time. We've received motions after deadlines. We've tried to be as courteous as we possibly can. And I appreciate the difficulty, but this is in no way a rushed process at all. And then fifthly, basically, the thread of defense that I have heard is that there's no evidence of knowledge. She was not aware. She did not know. There's no statement pointing to. There's no admission from her. But when you add up all the things that she did not know, it absolutely flies in the face of common sense. She didn't know about the finances of the family business, even though she was the CEO. She didn't know about the $5 million overpayment from the state of Florida. She didn't know where all the money from the consulting firms, the Truth and Justice Network, the Petrogas, Haiti, Progressive People, etc. All of that was outside of her information. And when my colleague across the dais here asked you about text messages that show, despite your argument, she was integrally involved in this. From her own phone, from her own correspondence, the max is 2 checks of $2,900. That is why sister had to give money to Najej for her to make another donation. Another text message. The goal is 2 million, at least 1.5 million. Hector Ruse responds, I suggest you move funds into the campaign account sooner rather than waiting towards the end of the month. This is the one chance to post a big number. Respondent, I am not planning on using that amount, just leveraging. I think that's a good idea. Response, indeed, but no one has to know that. At some point, and your response to him was, we got to get the full context. You and I both know that sometimes evidence speaks for itself, and that at a minimum says that she was integrally involved in the money moving around these various entities and people into her campaign balance. There was knowledge on her behalf far beyond what you have represented to this committee. And given all that we've heard, for all the reasons I just stated, again, I don't think it's been a very credible presentation to say there's material issues here.
I appreciate your position, Congressman. I don't think there's any conflict whatsoever in saying that she has thoroughly cooperated with the committee in this way. And if I can explain to you
Well,
what
the
I
fact that
mean.
you have to explain it indicates that she hasn't cooperated.
No, that's not true. She's turned over thousands of documents. She hasn't ignored the committee. She's had attorneys contacting the committee, contacting staff, discussing these issues with staff. I would understand if she just refused to discuss anything with the committee. If she didn't show up for this hearing, I could understand you taking that position. The reason that she's had the difficulty that she's had is because her criminal defense attorney before me came in and overrode the attorneys that were dealing with the committee and said, you can't turn these things over. Their hair was on fire because they're criminal defense attorneys, and the idea of their client turning over documents when they don't have to in the criminal world was absurd to them. So they said, no, don't do that. Don't talk to the committee. Don't turn anything over. So I understand you can blame her for that, but please understand what you're doing is holding her exercise of her Fifth Amendment right against her if you blame her for that. Because the only reason she didn't turn over those documents, the only reason she didn't sit for the interview was because she was advised not to turn over the documents and not to sit for the interview by her criminal defense attorney, who overrode the advice that her attorneys before this committee were recommending to her. But a lack of candor when she has gone out and spent money to hire attorneys to handle these discovery issues, and the attorneys are in communication with staff. I understand it didn't go the way staff wanted. I get it.
It's not staff.
Or the committee then. I understand it didn't go the way that the committee would have preferred. It didn't go the way that I would have preferred. If I was the attorney, it would have gone differently. But don't hold that against her because her criminal defense attorney advises her to invoke the Fifth Amendment and to not testify and to not turn over certain documents, because that's what criminal defense attorneys do every single day. And you know that as well as I do.
I do, but I've reminded you, we're not charging her with crimes. And for you to say that there has only been efforts to discuss this with counsel, or that she has said, I can't talk because my counsel has said, this is the first time we've heard this as explicitly as it has been relayed. So again, I'm not buying it. And I have seen the record. I've talked to staff. I've talked to the investigative subcommittee. There has absolutely not been a retreat on the advice of counsel. There has been a refusal to engage on any level. And that's where the credibility is falling apart. And I don't want to get into this any more than we have to, but taking it in full, it's tiring to keep up with the vein.
I understand, Congressman, and I appreciate your patience that you've exhibited thus far, definitely with me, by the way, that this committee has had with me. I appreciate it. I appreciate the extension of the time limits that you've given me. I think the committee has been very fair with me. But that being said, let me bring the lawyer in. Let me bring in her former criminal defense attorney who insisted that she not speak to this committee. Let me bring in the attorneys who recommended to her not to turn over the documents. I understand it strains credibility. Let me prove it to you. I can. I can call these lawyers in. We can call in her former counsel and have them explain why they didn't turn over.
You're making the point I just made. There's been total refusal up until this point, and now we want a full court press. That time has passed. Mr. Chairman, I yield back.
Gentleman yields. Mr. Subramaniam, we will allow you to wrap up questioning.
Thank you, Mr. Chair. Counsel for the committee, could you explain to us sort of the burden of proof that needs to be met for, I guess, to meet the counts that we're looking at?
Yeah, so under the rules that the committee has set for itself, it has to determine whether there is clear and convincing evidence of the violations that have been charged by the investigative subcommittee. That essentially means, is it highly probable? It is something less than reasonable doubt, but more than less than beyond a reasonable doubt, but more than substantial reason to believe.
And so, and under that instance, circumstantial evidence would point to that, or evidence that would maybe not be directly speaking to it, but would be sort of speaking around it. That would be enough.
If it's convincing, then absolutely.
And the counsel for the defendant, do you understand that to be the burden of proof we need to meet here?
I didn't catch her answer. Was it clear and convincing? Was the burden of proof that
Do you want to tell him again what your what the burden is?
Yeah, clear and convincing.
Clear and convincing.
I do. That's the same burden, for example, that a state has when they have a case over termination of parental rights and they want to take children away from parents that have been abusive. That kind of a case has to be proven by clear and convincing evidence. My point being that it is an extremely high standard, clear and convincing evidence. That's not the only standard that's before this committee, though. The first question is whether or not there are material facts in dispute.
Because so I'm gonna get to that. So then, for counsel for the committee, this is a summary judgment hearing. So could you explain what our burden is there too when it comes to summary judgment?
Yes. So the rules that the committee has adopted for itself borrow this phrase from civil procedure, that there is the option to make a determination that there is no material fact at issue. It's similar to summary judgment in the civil process in that it is a question of whether there is a dispute about the material facts. Committee counsel made that motion based on the record before it and the responses that it had received up to that point from the respondent. Some new last-second efforts have been made to introduce some disputes of facts, and I think it is within the discretion of this adjudicatory subcommittee to determine whether those are the material issue, whether those are material issues of fact that interfere with its ability to determine whether the evidence is sufficiently clear and convincing at this time.
And is that your understanding of summary judgment?
I want to clarify something, if I may, and that is that the committee's rule indicates that prior to deciding an issue like this on summary judgment, you must determine that there is no material fact at issue. So before you can even take a vote, according to your own rule, before you can even take a vote on whether or not to grant summary judgment, you have to decide, are there any material facts at issue? And if there is one material fact at issue, you cannot be voting for summary judgment. You have to allow it to go to an adjudicatory hearing so that we would have an opportunity to call witnesses, to cross-examine witnesses, and to have the truth come out as to what that material difference is. But right now, there are lots of material facts that are in dispute, a lot of them. And so there is no real avenue here for this committee to grant summary judgment based on Rule 23-0, which clearly states if the adjudicatory subcommittee finds that there is no material fact at issue, then you go on to the burden of proof. But before you get to the burden of proof, which is a very, very high burden, before you get there, you have to determine that there is no material fact in dispute. And I'm telling you right now, on behalf of the Congresswoman, we dispute these facts. And we would ask for an opportunity to have them heard in public through cross-examination and the calling of witnesses.
You are aware that you could have called witnesses today, right?
Yes.
Okay.
Yes,
Wanted to make sure.
I've had this matter on my desk, sir, for 21 days. I mean, in order to really prepare for this, I would have needed a little bit more time. I'm doing the best with the amount of time that I have, but we're not prepared to call witnesses at this time. We want to have our witnesses heard at the adjudicatory hearing, not at a motion practice where there's a question of summary judgment. Because from my understanding, all we have to do is raise that there is a material dispute over a fact. And once we do that, then we would be entitled to call witnesses. We'd be entitled to having an adjudicatory hearing, which is what happens every single day in courtrooms all over the United States. That's all I'm asking for, is an opportunity to cross-examine these witnesses, to put on our own witnesses, and to have a full hearing so everyone knows what all these facts are, rather than guessing.
I understand. Thank you. And counsel for the committee, you've learned some new facts here today, or learned some new disputes to facts today. Did you consider any of the facts you learned or the disputes you learned material to the findings that you made coming into today's hearing?
I don't think any of them are sufficiently material to make any of the counts charged not proved by clear and convincing evidence. I think that we discussed what underlies each of the charges. This is a set of conservative charges where, in many cases, multiple violations are sort of consolidated among individual charges. And I don't think anything I've heard today changes any of the conclusions that the investigative subcommittee arrived at.
I'll yield back.
I'll also just add that very little actual evidence has been introduced today. There were a few documents attached and some chart, but there's also just been a lot of representations from counsel. We still don't have any testimony under oath from the Congresswoman.
Gentleman yields back. Time for member questioning has concluded. Each side will now be given 5 minutes to make a closing statement or closing argument. Committee for the council will go first.
Members of the Adjudicatory Subcommittee, under rules of the House and committee, you procedurally have the discretion to decide whether you have sufficient evidence to rule today on whether the statement of alleged violation charges are proved by clear and convincing evidence. I submit to you that you do. The material facts alleged in the statement of alleged violations are amply supported by the record. As discussed in committee counsel's papers and during this hearing today, the material facts supporting the charges rely in large part on bank records, which are incontrovertible documents that speak for themselves. These facts are further supported by contemporaneous communications and records, as well as by testimony obtained by the investigative subcommittee. Respondent has argued today that the profit-sharing agreement predated the special election and overpayment that Trinity received. This is true. What is also true, as demonstrated by Exhibit 2 to the committee's motion for summary judgment, is that respondent had decided to run for Congress in January of 2021, before the COVID-19 contract with Trinity was signed. Respondent has also, or rather respondent's counsel, has also referred to the $5 million being the windfall, but the windfall was the COVID contract in its entirety. The record establishes that there was a scheme to impermissibly funnel Trinity's money to respondent's special election campaign via both direct transactions and using various conduits. In doing so, respondent violated numerous campaign finance laws, including the prohibitions on accepting corporate contributions, limits on the amount of contributions, and requirements that contributions be accurately reported. The sheer amount of pass-through bank accounts and entities involved demonstrates that she knew that this was wrong and wanted to obfuscate the true source of the funds. Notably, unlike the indictment, the charges in the statement of alleged violations do not require this subcommittee to make a finding regarding whether Trinity had a legal right to all of the funds that it received from the state of Florida in relation to the COVID-19 contract. Rather, the most pertinent question with respect to Trinity's funds is whether millions of dollars of those funds could lawfully be transferred to respondents' campaign, either directly from Trinity, from her family members, or from LLCs and bank accounts she owned or co-owned with her brother. The answer to that question is that they could not. Part of that inquiry is a related question of whether respondent had a right to all the Trinity funds she received. The record makes clear she did not. Moreover, in order to cover up this scheme and support her independently wealthy campaign persona, respondent and her campaign filed inaccurate reports with both the FEC and the House. In one of the more egregious instances involving her 2021 candidate financial disclosure report, the record indicates that respondent weighed the risks and then purposefully delayed filing her report until after she won the highly competitive primary, denying her constituents the ability to evaluate her public representations about the source of her wealth. Respondent's 2022 re-election campaign likewise relied on a clandestine and improper funding scheme. This time, hundreds of thousands of dollars from Petrogas Haiti were channeled through a newly formed company run in part by respondent's husband, which in turn passed most of its money on to another company, described by its director as effectively a fund created to facilitate respondent's campaign, and which was run in part by her campaign consultant, which then, predictably, spent the money in support of respondent's campaign. The campaign finance-related counts of the statement of alleged violations range from systemic reporting violations to very serious charges of campaign finance misconduct. The investigative subcommittee did not charge every last campaign finance misstep in a freshman congressional campaign, but instead focused on the clearest violations of unambiguous laws and standards of conduct. Respondent's misconduct was not limited to her campaigns, however. After becoming a member, respondent accepted voluntary services for official work from a campaign advisor, including for French communications. She also provided special favors and privileges in connection with community project funding requests. Finally, respondent repeatedly displayed a lack of candor and diligence throughout the investigative subcommittee's investigation, insisting she wanted to cooperate, but consistently failing to do so after November 2024. Respondent has put forth insufficient arguments today as to why the facts alleged in the statement of alleged violations, which are supported by the record, are at issue or do not sufficiently make out the charged violations. This is unsurprising given that the violations charged in the statement of alleged violations are supported by hard evidence gathered over the course of a thorough 2-year investigation. Because the counts in the statement of alleged violations have been proved by clear and convincing evidence, the adjudicatory subcommittee should grant committee counsel's motion for summary judgment as to all counts. Thank you.
Thank you. Closing on behalf of the respondent.
The greatest material fact in dispute right now is apparently whether or not she was entitled to the money that she received from Trinity. If I heard correctly, the argument from staff is that she wasn't entitled to that money, and we haven't proven that she was entitled to that money from Trinity. Trinity was a family corporation that's been in business for over 30 years. Her father had COVID. They thought he was dying from COVID, and the family sat down and talked about how to divide up the quote-unquote profits of Trinity. We introduced a document that I said was evidence of the existence of a profit-sharing agreement. I understand it is not your typical profit-sharing agreement that you would see if you owned a corporation and had lawyers handling these things for you. That doesn't mean it's not true. It doesn't mean that in the Haitian American community, family members don't put things in writing like that. They shake hands and they trust each other. But it's definitely evidence of one thing. And it's evidence that there is a very serious dispute here over the facts of the case. And whether or not the money from Trinity was entitled to go to her, whether or not the Congresswoman was entitled to that money or not, Well, that's the underpinning for all of these allegations that are being made. And what you have now is you have a piece of evidence that members suggested may be exculpatory that I've presented before the committee that's in front of you now that completely contradicts staff's argument that she wasn't entitled to the money. Well, if that's not a material dispute, I don't know what is. And so how can this committee be asked to just decide this before we get to the bottom of it? What I suggest is that we talk to the witnesses. We place them under oath in front of everybody. We put a TV camera on them and we ask them questions. And then we'll know what happened with the money from Trinity. And we'll know why the money from Trinity went into these different corporations. Because the evidence will show, if we have a hearing, that the work was done. That Trinity went out and helped tens of thousands of people get vaccinated who wouldn't otherwise be vaccinated. And yeah, the Congresswoman made a lot of mistakes on a lot of financial disclosure forms. There's no question about that. But the same mistake that they're suggesting she made over 61 times is misreporting her loans. And that's all based on their theory that she's not entitled to the Trinity money. And that is a factual dispute that we will dispute till the end of time because she was entitled to it. And the reason she was entitled to that money from Trinity is because her family said, you know what, Shirley, we're going to give you half of this money. And that was a decision that was made by her family. And if we need to bring the family members in to prove that to committee, we're happy to do so. And if we need to bring people in who received the services from Trinity, who got life-saving vaccinations, who wouldn't have gotten them but for the work of the Congresswoman in her community, we'll do that as well. But to suggest that there's no material fact and you can just decide to throw a woman out of Congress who was duly elected by her constituents because of bank records, quote unquote, well, that's not enough. If you want to sanction her, if you want to ask the House to sanction her, if you want to move into a different hearing where you consider a sanction, before you get there, make sure that these procedures are followed meticulously. And if it says that there is no summary judgment unless there are no material facts at issue, I would suggest to you that all this time we spent today proves one thing, and that is we disagree on the facts. And if we have a serious disagreement on the facts, if we have a serious disagreement over whether or not the Congresswoman was entitled to every penny she received from Trinity, well, then let's have a hearing. Let's call some witnesses, and let's get it all out in the open and be transparent about it, rather than deciding it based on conjecture, circumstantial evidence, hunches, and bank records. Thank you, Your Honor.
I want to thank counsel for both sides for their participation in the hearing this evening. I want to thank you for your argument, for your responses to questions on behalf of members of the adjudicatory subcommittee. At this time, the subcommittee will adjourn. We will move into executive session. We will meet to deliberate the motion for summary judgment. When a decision has been reached, we will announce it through a public statement released by the committee. And so with that, this hearing is adjourned. I just want to make sure since... Well...
She's not listed.
I need everybody to be able to ask questions. It's important.
This was in 2016 when I first started.